Good morning. This meeting will come to order. This is a public meeting of the U.S. Commodity Futures Trading Commission. I'd like to welcome members of the public and market participants, as well as those on the phone or watching via webcast. I'd also like to welcome my fellow commissioners, Commissioner Quintens, Commissioner Benham, Commissioner Stump, and Commissioner Berkovitz. This is the last open commission meeting of the year. And I just want to say that the holidays are a time to gather with friends and family and to recognize the year's successes. I think this commission in particular has a number of things that all five of us can be proud of, as well as the staff. It's also a time to remember family and friends we've lost. I'd like to call up Phil Ramundi of the Division of Market Oversight's Chief Counsel's Office. Phil's legal expertise, hard work, and enthusiasm have been an asset to this commission. In recognition of your contributions, Phil recently received the Chairman's Award for Staff Excellence. I've asked Phil to lead us in the pledge today in dedication to his father, Peter. Peter was devoted to the derivatives markets, made a career out of it, and he was one of the couple of thousand people killed on 9/11. We must never forget all those lost on that tragic day. And I know right now, Phil, that your father is watching and very proud of you. So, Phil, if you could lead us in the Pledge of Allegiance. To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. This morning we have a pretty busy agenda, so we're going to dispense with opening statements to leave plenty of time for discussion. On the agenda for today's open meeting are 4 items. First, there was going to be, and I'll talk a little bit about that in a second, a request for comment on EU collateral in clearinghouses. A proposed rule on the cross-border application of our swap dealer registration thresholds and certain regulatory requirements applicable to swap dealers. We know this in shorthand as the cross-border rule. And then we have next a proposed rule on name give-up, which would prohibit the practice of name give-up for swaps that are intended to be cleared on CEFs. And then finally, we have a final rule amending our clearinghouse general provisions as implementing the core principles. So we have a very busy agenda today. The first item on the agenda that I mentioned was going to be a request for comment on whether clearinghouses should be allowed to accept sovereign debt from certain EU countries as collateral, or the euro or other EU currencies for collateral and settlement. And as we've noted, the EU recently amended its clearinghouse rules to potentially designate non-EU CCPs in the wake of Brexit. But this law, EMIR 2.2 on its face, is much broader than just addressing the issues arising from the UK's withdrawal from the European Union. It could result in American clearinghouses being subject to contradictory and duplicative requirements by the EU, which arguably is a systemic risk to the United States. And I've stated before, and I know many of my colleagues, if not all of them, agree, that I don't believe any U.S. CCP poses a systemic risk to the EU. But the EU has raised concerns regarding the amount denominated in EU currencies, collected in margin, guarantee fund, and collateral, and they've also expressed concerns about third countries outside the European Union settling payments denominated in EU currencies. And the CFTC, the 5 of us, as well as the staff acting on our behalf, has the unilateral authority to address these things. And we will not hesitate to do so to avoid our clearinghouses being subject to an EU law that, again, on its face, would purport to override our own laws and regulations. So I personally do not have any problem with German or French government bonds posted as collateral, or even EU currency used as collateral or even for settlement. But we can easily revoke our no-action relief or amend our rules to prohibit certain types of foreign collateral that the CCP can accept for margin and settlement purposes. Also, in the interest of international deference, we have the ability to revoke previously issued Part 30 exemptions should we fail to get international comedy from our foreign counterparts. Now, I very much hope that we don't have to take such drastic measures. To that end, I've decided that at this point, I think we're going to withdraw that proposal, Mr. Secretary, for the time being, and we will not be voting on that today. On a positive note, I will say that over the last 3 months, we've had a very constructive dialogue with the European Commission and ESMA on this issue. And collaboration, of course, is key to implementing the G20 derivative reforms. I remain hopeful that the final delegated acts that will be published by the European Commission and ultimately implemented by ESMA will lead to strong cooperation and information sharing. We want even better oversight of international CCPs, but we don't want burdensome, duplicative, or even conflicting supervision. So stay tuned. We may or may not be presenting this and other proposals in the future. We're going to move on to the next agenda item, but before I do so, I just want to check to see if any of my fellow commissioners have anything they'd like to add. Okay. Well, then we will move on to our agenda of the remaining 3 items. For each of the remaining items on today's agenda, the staff will make presentations to the Commission. The Commission will then separately vote on each of these proposed, or in the final case, the final rule. After each staff presentation, the floor will be open for questions from each commissioner. Following the close of discussion on each matter, the Commission will vote on the recommendation. All final votes conducted in this public meeting will be recorded votes. The votes approving issuance of rulemaking documents will be included with those documents in the Federal Register. To facilitate the preparation of the approved documents for publication in the Federal Register, I now ask the Commission to grant unanimous consent for staff to make the necessary technical corrections prior to submitting them to the Federal Register.
So moved.
Second.
Thank you. Without objection, so ordered. At this time, I'd like to welcome the following staff for their presentation on our first agenda item, which is the proposed rule regarding the cross-border application of registration thresholds and certain regulatory requirements under our Part 23, which applies to swap dealers and major swap participants. From the Division of Swap Dealer and Intermediary Oversight, we have with us today Josh Sterling, Frank Fisanich, Lauren Bennett, Owen Copan, Rajal Patel, and Jacob Chaikin. Thank you very much, and you may go ahead and begin your presentation.
Well, good morning, Mr. Chairman, Commissioners. It's a pleasure to be before you once again, I think the 3rd time in 5 weeks perhaps, with another expertly crafted set of rules prepared by my world-class staff here in DSIO. Allow me a moment to start to explain our approach and how it aligns with the agency's mission statement and core values. First, our proposal achieves the value of clarity by taking a smart, effective, and practical approach to the cross-border rule set based on 7 years of real-world experience. That's because the proposal today is based on our 2013 swaps cross-border guidance in the main. I think it's only right to proceed in the many years since that time on an approach that honors on the equities the efforts of market participants to build systems and design corporate structures that align with the Commission's earlier pronouncement from 2013. In addition, as a division in this agency, we've observed over those same several years that the approach taken under the Commission's 2013 guidance has provided an effective basis for applying our rules on a cross-border basis. I would also say, as a second point, that the proposed approach benefits from a prudent dose of comedy. We recognize in the 10 years since the United States was the first mover on swaps reform under the 2009 G20 commitments, the major money center jurisdictions around the world have stood up their own swaps regimes. This has enabled regulators in those countries to join in our efforts to oversee what's truly a global and cross-border swaps market. And of course, we think those regulators have a legitimate interest in seeing their rules applied to activities in their own jurisdictions in the first instance. We've taken due notice of these developments and seek only to push specific requirements to the outer reaches of the globe when we have identified transactions and related activities that may have a direct and significant effect on United States commerce in keeping with the statute. In doing so, This approach is faithful to the requirements of Section 2I of the Commodity Exchange Act, which we necessarily interpret with principles of comity in mind. Third, we also achieve our value of clarity through a smart, effective, and practical approach that puts the requirements in the rules themselves with an appropriate degree of explanation in the preamble text. We think our text, for your consideration, is clear, simple, and direct. No one will need to be a student of the fine print, I think, to get our meaning. I have to say, I think this is particularly salient for readers of our rules worldwide who are regulated by us in some way, for whom English may not even be their first or second language. Fourth, we mean for this document, the proposal and the subsequent final rule release to be complete. I think this honors our goal of being forward-thinking. If the course we recommend is followed through, we don't expect that the Commission or its staff will need to issue letter relief to augment, clarify, or hold in abeyance any aspect of these rules. The rules are complete on their face and can be implemented with no more delay if ultimately adopted in some form than is customary in adopting a set of agency regulations. Of note, our proposal rejects the application of the requirements that it includes to non-U.S. transactions that are arranged, negotiated, or executed in the United States by U.S.-based personnel. These are the, quote, A&E transactions on which much ink has been spilled, but which have never gone into effect. The idea of A&E, as I recall, was put forward in an advisory that followed the 2013 guidance, and it's been held back since by no action relief. For reasons born of experience and considerations of comity, we recommend, as written, that you just say no to the A&E concept for these purposes. We can't miss what we've never used, after all, and my 2 decades of experience working in international markets tell me that we don't need to have it here. And more to the point, putting it simply, this agency should not need an extraterritorial provision in the statute to reach conduct that actually occurs in the United States. Allow me one more moment, please, to tell you why I'm so proud of my division's efforts in your behalf and on behalf of the American public. With this proposal, as with every other rulemaking we bring before the Commission, like Capital last week, you have the full measure of our good faith in carrying out our responsibilities under the law. We have worked for months to craft rule text in a fulsome and transparent way that has sought and benefited from diverse perspectives throughout the agency. These efforts have truly put paid to our other core values in this agency of commitment and teamwork. This is not to say that we have agreed with everyone on everything. But what it does mean is that we have all agreed to work together for the common good, even though we may disagree on the specifics from time to time. As we are all one team here, and in the holiday spirit of togetherness, I will thank those that have contributed to this proposal in no particular order and without attribution to their division or office. So hold on for a second, the list is kind of long. Amanda O'Lear, Nora Flood, Dan Davis, Stephen Kane, Sarah Josephson, Gloria Clement, Lauren Bennett, Peter Calls, Matt Dagler, Rajal Patel, Vince McGonigal, Margot Bailey, Jake Chaikin, Eric Remler and Lucy Hines, Paul Schlichting, Frank Vasanich, Dan Buxa, Carlene Kim, Owen Copon, Terry Arbit, Pamela Garrity. To wrap up, we think this rule fulfills our mission of promoting the integrity, resilience, and vibrancy of the U.S. derivatives markets. I think it's a paragon of sound regulation. And like Capital last week, it also marks the beginning of the final chapter of my division's Dodd-Frank rulemakings. I don't think any of us will be wistful when we're all done in this area, but my division and I are impressed with the tremendous amount of work that's been done by both this agency and market participants over the last 10 years. And in this sense, and to paraphrase former President Reagan, while we take inspiration from that past, like most Americans, we live for the future. And by the grace of the Commission's deliberation and judgment, as informed by our good advice, I'm confident that the Commission will be able to close out this chapter across border on Dodd-Frank in the new year, as we look ever forward to tackling together the new challenges and opportunities before that. Thank you for considering this rule today, and to get into the substance of things more, I'll turn this over to my colleague, Rajal Patel.
Thank you, Josh, and good morning. I'll start by noting that for ease of discussion, given that there are no registered major swap participants, we are focusing this presentation on swap dealers. However, the treatment of what swap positions would need to be included in an MSP's de minimis threshold calculation is generally similar to the swap dealer threshold treatment we're discussing. We'll start with a brief discussion of the defined terms. First, under the proposed rule, a U.S. person would be defined consistent with the definition of U.S. person adopted by the SEC in the context of its regulations regarding cross-border securities-based swap activities, and largely consistent with the definition of U.S. person in the CFTC's cross-border margin rule. Specifically, a U.S. person would be defined as 1, a natural person resident in the United States, 2, a partnership, corporation, trust, investment vehicle, or other legal person organized, incorporated, or established under the laws of the U.S. or having its principal place of business in the U.S. 3, an account, whether discretionary or non-discretionary, of a U.S. person, or 4, an estate of a decedent who is resident of the U.S. at the time of death. The proposed rule also includes a definition for principal place of business and states that certain international financial institutions would not be included in the definition of U.S. person. We believe that any person designated as a U.S. person under the proposed rule would also be designated as such under the cross-border margin rule. However, to provide certainty to market participants, the proposed rule permits time-limited reliance on any U.S. person-related representations that were obtained to comply with the cross-border margin rule. Under the proposed rule, consistent with the cross-border margin rule, a guarantee would mean an arrangement pursuant to which one party to a swap has rights of recourse against a guarantor with respect to its counterparty's obligations under the swap. In general, a party to a swap has rights of recourse against a guarantor if the party has a conditional or unconditional legally enforceable right to receive or otherwise collect, in whole or in part, payments from the guarantor with respect to its counterparty's obligations under the swap. For purpose of our discussion, a non-U.S. person would be considered a guaranteed entity with respect to swaps that are guaranteed by a U.S. person. In other words, a non-U.S. person may be a guaranteed entity with respect to swaps with certain counterparties because a non-U.S. person's swaps with those counterparties are guaranteed, but would not be a guaranteed entity with respect to swaps with other counterparties if the non-U.S. person's swaps with the other counterparties are not guaranteed by a U.S. person. Owen will now discuss the definition of a significant risk subsidiary that is being introduced in this proposal.
Thank you, Roger. The concept of a significant risk subsidiary would be introduced by the proposed rule in order to apply a risk-based approach to determining which non-U.S. subsidiaries of U.S. parent entities are required to comply with the Commission swap requirements. SRSs are those entities that raise particular supervisory concerns due to the possible negative impact on their U.S. parent entities and the U.S. financial system. Under the proposal, an entity would be an SRS if 1, it is a subsidiary of a large U.S. parent entity that has more than $50 billion in consolidated total assets, and 2, it satisfies a 3-part test of whether the entity is a significant subsidiary of its large U.S. parent entity. If a subsidiary is above a given percentage threshold for one of the revenue, asset, or equity capital significance tests, then the subsidiary would meet the definition of a significant subsidiary as to its parent entity. In addition, because the proposed rule applies a risk-based approach to determining which entities qualify as significant risk subsidiaries, the proposed rule would also exclude from the definition of an SRS 2 categories of entities that are already subject to significant regulatory oversight. The first are those entities that are part of U.S. bank holding companies and already subject to consolidated supervision and regulation by the Federal Reserve Board. The second are those entities subject to capital standards and oversight by their home regulators that are consistent with Basel III and are subject to a CFTC margin determination. Such capital and margin standards would adequately address the potential risk that the entity might pose to the U.S. financial system. I will now turn it back to Roger to discuss further definitions and the rules related to counting for registration purposes.
Thanks. To wrap up the definition discussion, the proposed rule also defines foreign branch, swap conducted through a foreign branch, U.S. branch, swap conducted through a U.S. branch, foreign-based swap, and foreign counterparty. These definitions are included to differentiate foreign and domestic swaps to determine if swaps need to be counted for registration purposes, and to determine the availability of exceptions and substituted compliance for the Group A, B, and C requirements, which we'll discuss later. Swap dealers would need to consider how they, their counterparties, and their swaps should be categorized under these definitions. For discussion purposes, we also use the term other non-U.S. person to refer to a non-U.S. person that is neither a guaranteed entity nor an SRS, or significant risk subsidiary. Now we'll turn to what swaps need to be counted for registration purposes. Under the proposed rule, a U.S. person would be required to count all of its dealing swaps toward the swap dealer de minimis threshold. With respect to non-U.S. persons, there are three categories of entities: SRSs, guaranteed entities, and other non-U.S. persons. An SRS would be required to count all of its dealing swaps toward the threshold. A guaranteed entity would also be required to count all of its dealing swaps towards the de minimis threshold. An other non-U.S. person must count its dealing swaps in the following situations. First, other non-U.S. persons must count dealing swaps where their counterparty is a U.S. person, other than swaps conducted through a foreign branch of a registered swap dealer. And second, they must count dealing swaps when the counterparty is a guaranteed entity, except when the counterparty is registered as a swap dealer, and except when the counterparty is a guaranteed entity whose swaps are guaranteed by a U.S. person that is a non-financial entity. Further, non-U.S. persons, other than guaranteed entities and SRSs, would be permitted to exclude from their de minimis threshold calculation swaps that are executed anonymously on a registered or exempt CEF, registered DCM or FBOT, and that are subsequently cleared by a registered or exempt clearing organization. Jake will now discuss the classification and exceptions from swap dealer requirements.
Good morning. I will be summarizing the classification of the Group A, Group B, and Group C requirements and certain exceptions from some of those requirements for certain foreign-based swaps. Those by a non-U.S. swap dealer, other than one conducted through its U.S. branch, or that are conducted through a foreign branch of a U.S. swap dealer. As you know, Title VII of the Dodd-Frank Act and Commission regulations thereunder establish a broad range of requirements applicable to swap dealers. The guidance divided these based on whether the requirement applies to the firm as a whole, an entity-level requirement or an ELR, or to the individual swap or trading relationship, a transaction-level requirement or TLR. The proposed rule does not address the same set of requirements as the guidance, so to avoid confusion that may arise from using the ELR-TLR classification, the proposed rule instead classifies certain regulations as Group A, Group B, and Group C requirements for purposes of determining the availability of exceptions from and/or substituted compliance for such rules. The Group A requirements include 1. Chief Compliance Officer, 2. Risk Management, 3. Swap data record keeping, and 4. Antitrust considerations requirements. Like the ELRs in the guidance, the proposed rule provides that these requirements would be impractical to apply only to specific transactions or counterparty relationships, and are most effective when applied consistently across the entire enterprise. The Group B requirements include 1. Swap trading relationship documentation, 2. Portfolio reconciliation and compression, 3. Trade confirmation, and 4. Daily trading records requirements. These requirements relate to risk mitigation and the maintenance of good record keeping and business practices. Unlike the Group A requirements, the proposed rule provides that, like TLRs in the guidance, the Group B requirements can practically be applied on a bifurcated basis between domestic and foreign transactions or counterparty relationships, and thus do not need to be applied uniformly across an entire enterprise. This would allow the Commission to have greater flexibility with respect to the application of these requirements to the transactions of non-U.S. swap dealers and foreign branches of U.S. swap dealers. Finally, the Group C requirements, set forth in Commission Regulations 23-400 through 451 and referred to as the External Business Conduct Standards, are broadly speaking designed to enhance counterparty protections by establishing robust requirements regarding swap dealers' conduct with counterparties. The proposed rule provides that these requirements focus on customer protection and have a more attenuated link to, and are therefore distinguishable from, systemic and market-oriented protections in the Group A and Group B requirements. Additionally, the foreign jurisdictions in which non-U.S. persons and foreign branches of U.S. swap dealers are located are likely to have a significant interest in the type of business conduct standards that would be applicable to transactions with such non-U.S. persons and foreign branches within their jurisdiction. Swap dealers, whether or not U.S. persons, are subject to all of the Group A, Group B, and Group C requirements by virtue of their status as Commission registrants. However, recognizing the potentially stronger supervisory interest of foreign regulators with respect to certain foreign-based swaps and the Group B and C requirements, and in the interest of international comedy, the proposed rule provides certain exceptions from the Group B and C requirements for registered swap dealers. Specifically, the proposed rule proposes 4 exceptions that are largely consistent with the guidance. First, an exception from certain Group B and C requirements for anonymous, exchange-traded, and cleared foreign-based swaps. Second, an exception from the Group C requirements for foreign-based swaps with foreign counterparties. Third, an exception from the Group B requirements for foreign-based swaps where both parties are other non-U.S. persons. That is, neither party is a guaranteed entity or significant risk subsidiary. Fourth, a similar exception from the Group B requirements for foreign-based swaps of foreign branches of U.S. swap entities with foreign counterparties that are also other non-U.S. persons, subject to a 5% quarterly cap. This exception would not be available with respect to any Group B requirement for which substitute compliance is available for the relevant swap. Swap dealers that avail themselves of these exceptions would be required to comply with the applicable laws of the foreign jurisdiction or jurisdictions to which they are subject, rather than the relevant Group B and Group C requirements for the swaps. However, they would remain subject to the CEA and Commission regulations not covered by the exceptions, including the anti-fraud requirements in Section 180.1. In addition, swap dealers would need to address any significant risk that may arise as a result of the utilization of these exceptions in their risk management programs under Commission Regulation 23600 or comparable foreign regulations. Thank you for your attention. My colleague Lauren Bennett will now discuss the proposed rules approach to substitute compliance for the Group A and Group B requirements.
Thank you, Jake. The proposed rule also outlines an approach for substituted compliance for the Group A and Group B requirements that builds upon the Commission's current cross-border framework. Specifically, the proposal would permit a non-U.S. swap dealer to avail itself of substituted compliance with respect to the Group A requirements where the non-U.S. swap dealer is subject to comparable regulation in its home jurisdiction. Further, the proposal would allow a U.S. swap dealer that is transacting through a foreign branch or a non-U.S. swap dealer that is not transacting through a U.S. branch to avail itself of substituted compliance with respect to the Group B requirements for swaps with foreign counterparties. The proposal would also establish a process pursuant to which the Commission would conduct comparability determinations regarding a foreign jurisdiction's regulation of swap dealers. First, the proposal outlines procedures for initiating comparability determinations, including a provision which would allow the Commission to undertake a comparability determination on its own initiative. Second, the proposal lists the information that outside applicants would be required to provide in connection with the request for comparability. The information is intended to provide the Commission with a comprehensive understanding of the foreign jurisdiction's relevant swap standards, including the ways in which they may differ from the Commission's own corresponding swap requirements. Third, the proposal outlines a proposed standard of review pursuant to which the Commission would determine whether a foreign jurisdiction's regulatory standards are comparable to the Group A and Group B requirements. The proposed standard, which is informed by the Commission's experience in assessing cross-border comparability, is intended to provide a flexible, outcomes-based approach that emphasizes comparable regulatory outcomes over identical regulatory approaches. This proposal, if adopted, is not intended to have any impact on the effectiveness of any existing Commission comparability determinations that were issued consistent with the guidance. Thank you for your attention, and we look forward to answering any questions you may have.
Well, thank you very much to all of you. I know a lot of time and effort went into proposing this rule. And again, it's a proposed rule, it's not final. And I know my fellow commissioners and I will have many, many questions as we talk about this. So what I'd ask the secretary to do actually in thinking about this is let's have a half an hour for questions. And then what we'll do is we'll put another 25 minutes on after that to give each commissioner 5 minutes to maybe say a statement. So we'll have a period of questions and then we'll have individual statements afterwards. Does that work for everyone? Okay.
Well, it works in concept. I don't know if, I mean, I might have like more than, I don't know exactly how many minutes of questions, or I haven't timed myself totally. So I just want flexibility to ask sufficient questions and make between a 5 and 10 minute statement.
You have flexibility. Just be mindful. We want everybody to give a chance to speak. So thank you. With that, why don't you go ahead first?
Thank you, Mr. Chairman, and I thank the staff for the presentation and the description of the rule, and I thank you for your work on this rule. It's a multi-year effort, and thank you for working with my office and incorporating things and not incorporating others, but we'll continue to work on it. Let me start off by just putting in a larger context what the issue is that we're talking about here. I see this rule as two fundamental issues, but it's really, they're related, but maybe that'll put in context because the presentation was excellent, but it was very technical, so I'm going to take it up a level. What's the basic issue? What we're trying to decide, what the Commission is struggling with today, and what this rule proposal tries to get at is U.S. banks, many of them are global. Our banks have a global presence. When a U.S. bank has an operation overseas, how much should we regulate that bank under U.S. law, or how much should it be regulated according to its host jurisdiction? The proposal actually does a good job of describing the risks that are presented to the U.S. financial system from the operation of our banks overseas. When Jpmorgan or Morgan Stanley or Goldman or any of our banks operating in London or in Asia, Japan, Korea, wherever they operate, undertake these transactions, they're U.S. banks. Fundamentally, those risks are going to come back to the United States. Okay, and it's our financial system that bears those risks, and the proposal lays that out, I think, accurately and well. The problem is, if we just said U.S. law applies to everything those banks do because they're U.S. banks, is these banks have to compete overseas in overseas markets. And one is the overseas jurisdictions want to apply their laws to our banks operating in their territory. And secondly, if we insist 100% on our laws across the board for everything a U.S. bank does, other banks may not want to deal with those U.S. banks. They may say, well, I don't want to comply with U.S. law. I'm a Korean bank. I want to transact with other banks that follow Korean law. I'm not going to comply with U.S. law, and therefore U.S. banks will be at a significant competitive disadvantage. How do you balance the protection of risks coming back to the United States with the competitiveness of our banks overseas and our ability through U.S. banks of end users to use U.S. banks to access foreign markets? It's not just the banks, it's enabling U.S. companies and persons to use U.S. banks to access these overseas markets. We don't want to have U.S. citizens having to use foreign banks for all their banking overseas. So it's enabling U.S. market participants access to these foreign markets, but at the same time, it's protecting the U.S. Financial markets from these overseas activities, and it's getting the balance right between the application of our laws and the application of other jurisdictions. And when can we say it's okay to apply with foreign laws? The Commission first tackled this in 2013, and that's what the guidance did, and the structure that we're building off and it's been in effect basically struck a particular balance. And one of the things it did is when do risks really come back to the U.S.? What's a critical feature of the relationship between a foreign bank and a U.S. bank that brings that risk back to the U.S.? Well, it's if there's a guarantee. If the U.S. parent is guaranteeing the transaction, that's definitely bringing it back into the U.S. And the 2013 guidance had a broad definition of guarantee. It said it doesn't just have to be a formal written guarantee. It can be anything that effectively brings that risk back. And that's when we pulled in the non-U.S. affiliates through that broad definition of guarantee. And then we had various other rules for when particular requirements might apply to that entity and which swaps various non-U.S. entities had to count. But we had a broad definition of guarantee in that 2013 rule, recognizing that even if it's not a formal written guarantee of a swap transaction overseas, if it's some other arrangement, it's going to bring the risk back to the U.S. So Cftc has a strong interest. You're going to be treated like a U.S. swap dealer in many respects. And there may be substituted compliance for some of your transactions. The prudential regulators promulgated a margin rule for when U.S. banks had to collect margin for uncleared swaps. And the prudential regulators in their margin rule in 2013 had a cross-border component to it also. And they went much further than the CFTC went in 2013. The prudential regulators didn't use the concept of guarantee, but the prudential regulators, looking at it in a broad sense, saying if it's a foreign consolidated subsidiary, if the balance sheet of the U.S. If the U.S. bank consolidates its affiliate on the balance sheet, it's effectively the risk is being brought back. And it's the prudential regulators in 2013 who said that's really the test. Is the balance sheet consolidated? And when the balance sheet is consolidated, whether there's a guarantee or not, the risk coming back to the U.S. And we, in our margin rules, follow the lead of the prudential regulators. And so our cross-border margin rules adopted this concept of foreign consolidated subsidiary. It said, we really don't need to pay so much attention to the guarantee, because if it's consolidated, that's the test that's going to bring it back, and that's where it's going to be treated as a U.S. entity for the margin purposes. We didn't need to pay so much attention to the fact of a guarantee. So we narrowed the definition of guarantee in that rule, because those entities, even if it wasn't a broadly defined, unspecified guarantee, it would be included in this concept of foreign consolidated subsidiary where it's consolidated on the balance sheet. And that is our cross-border margin rule, okay? In 2016, the Commission said, well, why don't we use this concept of foreign consolidated subsidiary as the prudential regulators do, and instead of having this guarantee concept like we did in 2013, why don't we just treat all these U.S. affiliates as U.S. persons if it's a foreign consolidated subsidiary? So that was proposed in 2016. And basically, the banking community, if I may use a colloquial expression, went ballistic on that proposal, okay? And they felt that if we had such a broad envelope bringing in non-U.S. affiliates of our banks, that would really harm their competitiveness and really be detrimental to their ability to conduct business overseas. So that was very strongly objected to in 2016. So here we are today, again, trying to get the right balance between how far do we reach and how far do we protect, how far do we reach overseas to ensure that our banks are protected? And the question is, did we get the right balance today? My personal view, I'll say it at the outset, my view is the 2013 plus some of the modifications pretty much got it right. And for reasons we'll get into, I'm concerned that today's proposal, and it is the fine print in the proposal, it is some of the things that were outlined in the presentation, is the fine print that makes it a concern of whether we've got the balance right or not. So let me actually ask some specific questions. And maybe the first question is, because there's talk in here, particularly when we're going to get into significant risk subsidiary and whether there's going to be deferring to other regulators of deferring to prudential regulators. There's two tests in that: prudential regulation, capital and margin prudential regulation, whether prudential. Can you just say what prudential regulation is and how it is similar or different or to what we do? I mean, can you maybe explain prudential regulation?
Sure. So the preamble cites to the Federal Reserve supervision, bank holding company supervision manual, which sort of goes into explaining the Fed's broad powers to regulate the foreign activities of bank holding companies. And those powers include, and it lists a number of them, but briefly, the authority to establish foreign branches of national banks and regulate the scope of their activities, as well as conduct examinations at the foreign operations of U.S. banking organizations. And those exams may include reviewing for the accuracy of financial and operational information, as well as test the adherence to safe and sound banking practices.
And that's typically things like capital and margin and those types of rules? Or?
Well, You'll forgive us, Mr. Commissioners, not being bank regulators. Of course, we did look into it, but our understanding is that consolidated supervision by a federal banking regulator of a bank and its foreign operations is extensive. I would say it does get into operations and permitted and non-permitted activities. It's very close. And my sense of it, and talking with the team about it and others in the building, is that that's a very good standard, and it's not clear that we would necessarily be additive in that context, given the rules that are captured in this proposal, sir.
See, what we do is not additive. Are we redundant of the prudential regulators?
No, sir, I don't mean to say that we're redundant. I think that we take great comfort in the fact that the prudential regulators, which do have a primary oversight of banking organizations, do have complete authority in a way that I would say that we're comfortable looking at and saying, as we consider where we focus our resources, it wouldn't be necessary to do it in that context. So it's more judgmental than a declaration of redundancy, sir.
Let me ask you, do you think some of our swap dealer requirements that are in Title VII, the 4S procedures particularly as applied to banks, are those redundant with what the prudential regulators do?
I wouldn't say they're redundant.
Okay. Let me give an example of an overseas activity where I think we added value, and that's the London Whale. London Whale, if you recall, was activities, and frankly, it's not exactly clear where all these trades were booked, but it was conducted out of the London office of Jpmorgan, done by the CIO office there. I'm not sure exactly where it was booked, and frankly, it's not particularly critical. We know that was where it booked. It was actually the events happened before our swap dealer regulations were in place. But the CFTC did issue an enforcement action against Jpmorgan and the London Whale for $100 million for attempted manipulation of the market. But let me read you what we said in 2014 about in our enforcement order. This is the Commission's enforcement order on the London Whale. Jpmorgan's management of the SCPs, that's the division there, risk during the first quarter of 2012 was wholly inconsistent with principles of sound risk management, principles that have been incorporated into many of the risk management provisions of regulations 23600 to 23607. Indeed, had the regulations been in place, this is our swap dealer regulations, much of the offending conduct at issue and the significant losses it caused may well have been detected and remedied internally much more quickly, thereby potentially reducing losses. So this is our 23600 risk management procedures for swap dealers. These were prudentially regulated institutions at the time. And the Commission's view at the time was, the Commission said in 2014, in our enforcement order, we hit them up for $100 million, that our swap dealer regulations could have prevented it. The prudential regulators didn't prevent this. They didn't have risk management procedures like we did. So our regulations add value and they can prevent significant market events for swap dealers that implement them. We can't just rely on prudential regulators for something like this. Would you agree that we add value like this?
I think that our enforcement powers are broad and are used effectively. I think that, sir, in proposing a rule, we need to be, if I may, more circumspect than we are in writing what I presume is a settlement order that's phrased as a had, meaning counterfactual. And so I think we have to take due notice of things that do exist in the world and that do happen, which includes comprehensive regulation of overseas activities of banks by prudential regulators. And so we have tried, in particular in our rules, to make a judgment about where we think that we can provide proper oversight. So that's my sense of it, sir.
Okay, well, I appreciate your view. I have a view that happens to agree that with what the Commission said when it fined Jpmorgan for $100 million and said they didn't have adequate risk management procedures in place. And if they had our swap dealer risk management procedures in place, maybe it would have been prevented. And that banks should have, who engage in these activities, if they're swap dealing, if they're swap dealers, They should have risk management procedures in place like 23600. It's not just my opinion, it's what Congress said. It's what Congress said in Title VII of the Dodd-Frank Act, and Congress said if those activities have a direct and significant effect on or connection to, not just effect on, its connection to activities in the United States. It's not just a risk-based test, it's also a relationship test. It's an activity-based test that our swap dealer risk management procedure should apply. It's a congressional mandate, not a question of opinion. So let's move on to the guarantee issue. As I mentioned, the guarantee is one of the components that the Commission traditionally has looked to determine whether the overseas affiliate needed account swaps and whether its counterparty needed account swaps towards the dealer threshold, and then the various applications of the requirements that apply to swap dealers and transactions and conduct. But the proposal narrows the definition of guarantee. Is that correct?
Yes.
And why does it do that?
So the narrower definition than that in the guidance, as we've stated in the proposal, we believe achieves a more workable framework for non-U.S. persons, particularly because the definition of guarantee that we're proposing is consistent with the definition that exists in the cross-border margin rule. And therefore, we believe that market participants would not have to do a separate independent assessment of whether or not a guarantee existed. With that, and we still believe that the definition doesn't undermine the protection of U.S. persons in the U.S. financial system.
Okay, I appreciate that. I'm not convinced. We've had the definition of guarantee in that proposal for a while, and as I also noted, although it is consistent with the cross-border margin rule definition of guarantee, the reason the cross-margin rule could accept a narrower definition of guarantee is because those entities were brought in under the concept of foreign consolidated subsidiary. So we didn't need to have such a broad definition of guarantee.
Maybe could you ask one more question, Commissioner Berkovitz, and then I'll move to Commissioner Stump?
Well, can I have another round of questions? I'm not done with my, I have more questions. Mr. Chairman, we've had this proposal for 3 weeks. I think, and the commitment is that we're going to have an open public meeting on it, and I think I ought to be able to ask as many questions as I've got on this to have a full discussion. I'm not agreeing to only one more question.
You can use the allotted time afterwards to ask more questions.
Okay, well, I'm happy to defer to my colleagues now, but I have more questions.
Okay.
I'm not agreeing to any time limit on my question.
And all of us do have written statements as well that we'll be issuing.
I'm also going to have an oral statement I'm going to issue at this meeting too. Mr. Chairman, I have not objected to any process so far, but I will strongly object to any attempt to limit what I can say in public at a commission meeting. And I think it's inappropriate to ask me to limit the number of
We
questions
do
I
need
may
to
have.
keep the process moving, so if I
Mr.
could
Chair,
ask you to move.
We don't. We need to have a debate. The most important thing is not to keep the process moving. The most important thing is to get these rules right and to make sure we're protecting the market.
That is fine. You can ask as many questions, but you took 7 minutes to make a public statement before asking a single question.
7 minutes. Oh my gosh, Commissioner Berkovitz took 7 minutes on a swap dealer rule. Mr. Chairman, is 7 minutes too much for me?
We'll come back to you. No, I'm just asking that this time has been set aside for questions. So we just want to ask questions here.
That's what I'm asking questions. We're having a public meeting.
Please continue.
This happens at a public meeting. Okay, thank you.
Want to move things, that's all.
No.
All right, continue. Why don't we'll move to Commissioner Stump. We'll come back to you, Commissioner Berkovitz. Thank you.
So I have a few questions. I have a fairly lengthy statement too, so I'm going to try to follow the procedure that's been laid out here. I wanted to point out, most importantly, that some of what we're doing today is getting lost in the fact that we have guidance on the books that is not today enforceable. So we all were not here in 2013 and 2016 in our current capacities, but what we're left with dealing with today is trying to get the guidance to a place of an actual rule that is enforceable. And some might have us believe that we are abandoning our charge and rolling back regulatory oversight. I would suggest just the opposite. We're actually transitioning from non-binding guidance to a rule that, if adopted as final, would for the first time impose binding obligations with respect to cross-border activities, swap dealers, and major swap participants. If those rules are violated, I expect that we would bring enforcement action as a result of the transition from guidance to binding rules. But because they will be binding and enforceable, what we're attempting to do today is make the rules more clear, more sensible, and more workable. Ambiguous rules make for challenging enforcement. So I have a question for the Office of the General Counsel. The cross-border guidance isn't binding, is it?
That's correct.
Could the CFTC today bring an enforcement action against a defendant for violating the cross-border guidance?
I can answer that, Madam Commissioner. The answer is no, they cannot.
So when we talk about the London whale specifically, my question is, at the time when that occurred, under the cross-border guidance we had issued, we wouldn't have been able to bring an enforcement case. We were able to bring an enforcement case under our broad anti-manipulation authorities. But since that time, have the UK regulators put in place risk management regulations comparable to our 23600 risk management rules?
Actually, for for a swap dealer located in London, they've had substituted compliance for EU rules since 2013. So to the extent that, for risk management, so to the extent that it would occur post 2013, they would have been following the EU risk management rules rather than our rules on a substituted compliance basis,
Because we found them comparable.
because we found them comparable.
Thank you. That's all I have for now.
Okay, Commissioner Benham.
Thanks, Mr. Chairman. Just to follow up on Commissioner Stump's point, do we have any authority under our adjudication authority through the APA to bring a case against a foreign entity, specifically if we're going to talk about the London whale matter and the sort of juxtaposition with the enforcement authority we have? We have adjudication authority under the APA to sort of engage with market participants. Would we have had authority under that specific provision within the APA to bring that matter or to have a discussion with the entity in London?
Forgive me just one second, Mr. Commissioner. I'll have to confer with General Counsel's office on that. I'm sorry. We may have a question about your question, so.
I guess I'm not following the question, Commissioner
So,
Benham.
and this is more, believe me, I need to educate myself, but we do have adjudication authority under the APA. Is that correct?
Yeah, that's different than our
Enforcement
than our
authority.
enforcement authority,
Certainly, but
right?
it's a mechanism to engage with registrants and market participants, the adjudication authority.
Yeah, we can
to
make
see-
we make adjudication decisions when we adjudicate like a registration or a comparability determination is arguably an adjudication.
So to the extent that there was some risk out of that entity in London, could we have used our adjudication authority to engage with that entity to the extent we thought it was bringing risk back to the U.S.?
If it's a registrant, yes, we could have used our authority to engage with that entity.
Okay, that's all. Thank you. As a very high-level matter, I guess, for you, Director Sterling, I think the document that we received Monday afternoon had changed the comment period from 90 days to 60 days. Was there any particular reason you did that?
Sir, that's my fault. We had an oversight. I think the 90 days was carryover from an earlier draft. We'd actually always intended it to be 60 days, so that was a oversight in an earlier draft, and I apologize for that.
Okay, I guess just as a general matter, though, I would request that the mistake be sort of reinstated. Given the depth and breadth of this rule and the importance of it to the broader market, and the complexity, I would hope at the minimum that we provide 90 days, if not more, given what's ahead and the fact that the market will need time to respond appropriately. So just going to put that request in for both you and the chairman.
Thank you, sir.
On page, I'm going to make a couple references to the document, specifically the one I think we received Monday afternoon or Monday evening. And this is a general question about the decision to go to a final rule as opposed to maintaining status quo with the guidance. There's a brief sentence in the middle of page 15, and you don't need to look it up. It just says, in that regard, given due regard to how market practices have evolved since the publication of the guidance is an important consideration. The general thrust of my question is market practices have evolved. So you mentioned that we've had this several years of experience to sort of see how Title VII rules and regulations have been implemented, how the market's reacting. The guidance provides a bit of flexibility, right? And for technology reasons, for socioeconomic reasons, for geopolitical reasons, for any number of reasons, the markets have evolved and they will continue to evolve. Do you think that the guidance provides us a level of flexibility that enables us to move with the markets in a more nimble way as opposed to putting something into a formal rule and potentially being boxed out, or in many cases not limited to our jurisdiction or this agency, having the marketplace work around a very formal rule set?
Thank you for that question, Mr. Commissioner. I appreciate the point on flexibility. I think there's a necessary need to balance that with the notion of certainty, and we feel having final rules and the certainty that they provide is useful. A concern I would have in attempting to administer a cross-border regime is if we had guidance and then a series of no action or other written interpretive letters, it could become a bit of a construct, if you will. And if we try to get as much right that we think is durable, and the rules will be in a better position. I know it's important in the interest of transparency, as the chairman's articulated, to try to use rules where we can as opposed to non-rule based promulgations.
And I agree with that 100%, but I for whatever reason, I think, and I don't know if you recognize this or you agree with me or disagree, but the cross-border rule set and our cross-border jurisdiction is highly complicated. It's technical, obviously, in nature, but it's a matter of the global marketplace, so we have to be particularly flexible in this space because it's not only sort of the oversight of our domestic markets, we have to be able to appreciate the scope of the global markets and be able to adjust. And, I think there's a case to be made if you think about after the 2013 guidance came out, the 2014 district court case, in my view, seemed to affirm that the guidance wasn't a move that the CFTC both could make and was appropriate at the time, specifically given Section 2I and what Congress intended for this regime to be. So I'll say this in my statement a bit later, but I do caution against the idea, and I would hope that we would be a little bit more, and I mentioned this to you and your team last week. I do recognize and I appreciate the fact that the questions are very objective within the context of this rule. I think despite the rule not going in a direction I particularly like, I think the comments and the questions specifically that are asked and the comments that we're requesting are going to give the public an opportunity to weigh in, not specifically on the sort of thrust of where this rule is going, but what market participants think, what the public thinks, and whether or not we should keep things as status quo or move to what the proposal intends to do.
I would just say thank you, sir. We appreciate that observation. As with any proposed rulemaking, we are intently interested in what the public has asked to say to sort of show us where we're pointing and whether that could be better. So thank you.
So there's another high-level question. We're shifting towards a risk-based approach here. Is that correct? Is that fair to say? Seems to come up in the document quite often.
Well, I agree in the sense that we provide an interpretation of Section 2I that talks about, yes, what indeed are the risks to U.S. commerce, to the U.S. system. So in that sense, yes, sir.
And this is where I need help sort of bridging a gap between 2I and this sort of risk-based approach evolution. In my mind, when I read 2I, it's fairly specific and affirmative in mentioning activities, right? And when I read the language, swap provisions of Title VII shall not apply to activities outside the United States unless those activities have a direct and significant connection with activities in or effect on commerce of the United States, and contravene such rules or regs as the Commission may prescribe or promulgate as necessary appropriate to prevent the evasion of any provision of the CEA. How are we going to distinguish between activities, and I know this goes to a lot of questions and a lot of uncertainty that has existed since 2013, but by moving towards a risk-based approach, are we flying in the face of what Congress intended to have a more prescriptive oversight of specific activities if that activity has a significant connection on commerce of the United States?
Thank you. So I appreciate your question, sir. I hadn't realized that perhaps you're suggesting a distinction between a looking at risk on the one hand and a focus on activities as a separate concept on the other. And what I would say is I think that the construct we have with Group ABC requirements and how they apply to various permutations is indeed activities-based. I think that risk is a consideration we have when we try to think about what else ought we need to capture, and that's where we think about that connection of that risk into the United States and U.S. commerce. So certainly, risk can express itself in many different ways. One way would be through the mechanism of a guarantee. That concept is in here. One area it could express itself is through sort of a non-guaranteed entity that is still a big chunk of a big U.S. company that's not supervised, and that's a roundabout way of saying a significant risk subsidiary. So we're trying to find or identify where we think this risk could otherwise arise through different mechanisms to round out our coverage, we think. And in that sense, we also look to the second prong of 2I, which expresses concerns about evasion, and that, of course, strongly implies risk ought to be a focuser.
So you mentioned SRS. Let's just talk about that a little bit. And I don't want to be redundant to where Commissioner Berkovitz was and may go in the second round of questions. But we have 107 swap dealers, I think. Is that somewhere in that ballpark?
Yes, sir.
Yeah. So do you expect, if this rule were to go final as is that number going to change?
We do not believe so, sir.
Do you have any expectation how many entities would be designated as an SRS based on the prongs that you have laid out there?
We do not. That would take some global omniscience and facts finding that's not in our possession or perhaps anyone's. I think it may be that SRSs exist today. It may be that they could exist in the future. And so it's an effort to sort of look out and say, what do we think we really ought to capture that we're not sort of under these identified constructs of ABC categories and guarantees. And so this is a formulation we came up with some research and analysis, and of course we're opening it for comment.
What is, I mean, and if you haven't thought about that, that's fine, but like what is essentially going to be the enforcement mechanism or sort of the way we scope out SRSs, make that sort of determination? What's the process that you foresee as a possible workable solution to making SRS decisions?
Right. Excuse me. So I thank you for that question, sir. I think the decision is really to sort of identify in the rule text what we think the entity is, and then it requires an analysis by participants in our markets. And I would say, as I sit here, to my way of thinking, it's no different than or rather very similar to, an asset manager in another jurisdiction saying, well, have I become a commodity pool operator, or someone who is trading in futures contracts in the United States? Well, am I be an introducing broker on behalf of anyone else? So it requires knowledge of and awareness of the law, just like a registrant category. That's my sense of it, sir.
That's fair. But, it certainly is going to be a bit more challenging. My assumption is that it's going to be a bit more challenging given, we're not dealing with domestic entities here and the sort of complex web of the larger holding companies that we're going to have to be examining. I want to just, and I don't, again, out of interest of time, I don't want to be repetitive, but I do sort of want to associate myself with Commissioner Berkovitz's comments about the prudential oversight of SRSs, or the prong where if, if the 50 billion threshold, and then if the entity is, or if the, and correct me if I'm wrong, right, but if the parent or the holding is a prudentially regulated entity, then the potential SRS can't be an SRS or something of that nature. Is that right?
That's right. If it's prudentially regulated, then it
It
falls
can't.
out of the
It
analysis.
falls outside the scope.
Yes, sir.
And I just want to mention that I do think, we are talking about a registration threshold. That is the thrust of this exercise, of this cross-border rule. Our dealer registration under 4S and then under the 2300 rules is fairly specific, and registration serves a very different purpose in my mind, as opposed to what, and Owen, I appreciate the way you laid out the sort of core responsibilities of prudential regulators, but I do think there's a divide there, and we will be missing something if we just quickly defer and punt to a prudentially regulated entity and not implement the registration factors, or the sort of the benefits of a registration regime. And I think that above all else sort of flies in the face of congressional intent. So I'm a bit concerned about that and whether or not that prong is appropriate to consider within the SRS context. Margin, and Rajal, I think you mentioned this. If you can help me understand, there's a little bit of a distinction that I've identified, and correct me if I'm wrong, but we refer to the cross-border margin rule and align the definitions with respect to guarantee, but we draw a distinction with the unlimited U.S. liability prong. Is that right?
Yes, that's correct.
So can you, when I think about margin, I think about counterparty credit risk, and again, this goes to what I was saying earlier about the registration regime. There's different purposes to which why we do our regulatory oversight, whether it's regulation or whether it's capital and margin, or in the case of a prudential regulator, safety and soundness. Why do we have this inconsistency with respect to these two pieces, thinking about the 2016 margin rule?
So just to make sure I understand the question, or to clarify, you're referring to the unlimited U.S. responsibility prong that exists in the U.S. person definition in the cross-border margin rule.
Correct.
So yeah, that prong is not in the proposed rule. As we stated in the proposal, our belief is that the corporate structure that the unlimited U.S. responsibility prong is designed to capture is not one that is commonly used in the marketplace, but we request comments on whether this understanding is correct, and if not, whether we should reassess if that prong should be included in a final rule. And so we're basically asked for comments, and then we look forward to seeing what market participants tell us.
And again, correct me if I'm wrong, but there's an effort to align ourselves with the 2016 cross-border margin rule with respect to guarantee and the definition and scope of guarantee. Is that correct?
Yes.
Right. And I understand that we are striking the U.S. Liability prong from this proposal, but asking comments or requests for comments of whether or not that's the right decision.
Yes.
But then we're aligning ourselves with respect to the liability prong on the 2016 cross-border margin rule and saying that it's okay to sort of use that as a reference.
So we're not including the unlimited U.S. liability prong that exists in the 2016 cross-border margin rule. Right. But, we're harmonizing, just generally speaking, I think we're harmonizing in the places where we think it makes sense based on our 7 years of experience in the market and 6 or 7 years of experience with the guidance.
So do you think it's appropriate, given, again, the distinction of what margin is going after, and in my mind, primary purpose is counterparty credit risk, is it appropriate within the context of a cross-border rule that is focusing on dealer registration thresholds to reference a 2016 cross-border margin rule and the definition or the scope of guarantee within that rule? Should it not, you mentioned this earlier, I think this was a conversation with Commissioner Berkovitz, but the definition or the scope of guarantee is being reduced. And I'm wondering why are we referencing the 2016 cross-border margin rule to sort of think about the scope of the definition versus thinking about this within the lens of this rule before us.
Absolutely. No, thank you for that, sir. Excellent point, of course. I think that our sense was we do have a definition of a guarantee going back to the 2013 guidance, which is admittedly quite broad. And I think that for the purposes of the rules we cover, which are significant and do include registration, that was a very broad definition. I think since that time, standing up our swap dealer registration regime, we've had many firms register. We have tried to align ourselves with things that have been iteratively updated in the cross-border context, including that definition. But I think our judgment was we didn't need to take it whole hog, and that's a determination we've made. And as Rajul pointed and you rightly observed, we do ask questions about that. I think we do feel comfortable with the proposal as stated. Thank you.
Thanks. And the final question I have is, there's a reference in this document to Wickard, I believe, is the case, and it's sort of it's a Supreme Court case, and it's a reference to sort of aggregate effect. And, you know, without boring the audience here, the Wickard case deals with a farmer who doesn't even sell his production, his wheat production, but there's a sort of discussion about what effect that individual farmer's wheat production will have on the larger market. And moving beyond that, but using it still as a reference, I want to read a sentence from page 30, which was amended on Monday evening. And the original sentence said, in exercising its supervisory oversight outside the United States, however, the Commission will do so only when the activity has a direct and significant connection to the U.S. financial system. And that was the original version. And Monday evening, we received a revised version, and the revised version says, in exercising its supervisory oversight outside the United States, however, the Commission will do so only as necessary to address risk to the resiliency and integrity of the U.S. financial system. And that's pretty concerning to me because, again, going back to the discussion we had earlier about the definition of 2I and the very explicit inclusion of the word activities in 2I, I wonder and question and I'm concerned about the fact that are we shifting too far away, taking into consideration the importance of certainty and adapting with the market as it does as well? Are we perhaps going too far away from congressional intent on examining activities and just looking at things at a very, very macro level about resiliency and integrity of the U.S. financial system? Those are terms that are from 2008 and that go to the sort of thrust of what we went through after the crisis. And I question whether or not that's the way we should view this, and whether or not it is way too broad and does not really identify, to go back to the Wickard case, not necessarily just the macro big issues that will have an effect on any ecosystem, but potentially identifying the smaller issues. And they may not be small individually, but as a reference and relative to other issues, thinking about institutions, foreign institutions that may not directly pose a systemic risk, but in the aggregate, if we are not looking at these entities alone and also in the aggregate, perhaps we're going to miss something, and perhaps that risk will come back to the U.S. I have a big concern with, I think, the shift in the sort of theme of the way we're going to view cross-border, and there's too much at stake. And granted, as I'll say in my prepared remarks, we certainly need to evolve and we need to adapt. But I would hope that we are staying focused on entity-level activities as Congress dictated, so that we observe and identify potential risks to the U.S. system. I will stop there. I want to thank all of you for your hard work. And certainly I know this is a challenging role. And Director Sterling, I appreciate your comments at the beginning of recognizing all the individuals, not just all of you who spent many hours putting this rule together over many months. But I would like to add my two staff, John Dunphy and Laura Gardy, who did a tremendous amount of work to get us to here. and to hopefully, as we always try to engage with your office to make these rules better.
Thank you, sir.
Okay, thank you. We're going to move to Commissioner Quinten's, but we are going to have another round robin of questions after each of us has an opportunity. So we'll have another round of questions, and then we'll go with closing statements. Just want to make sure everybody has a chance here.
On that point, Mr. Chairman, a number of us have worked on the Hill. I personally consider the House and the Senate to be some of the most robust and august deliberative bodies in the world. Do you know how much time senators or members of Congress have during committee hearings to ask questions?
Well, during my confirmation hearing, it was 5 minutes apiece. I
So
wish it
even
were a
if they
minute apiece,
did
but it's-
another round of questions, that would give them 10 minutes of questions, right? So if they did 3 rounds of questions, which I've never seen before, maybe it happens, that would give them 15 minutes in bodies that are the most deliberative bodies in the world. Now, we all live in a world of limited time, and I appreciate the balance for transparency and the ability to articulate views. One place where time is unlimited to articulate those views is online. I would like to try to make sure that I use my time here more for questions than for statements. So let me get into that quickly. Chairman Gensler, when he was in front of one of those August committee bodies on the Hill, was asked a question about how many swap dealers he anticipated his rules covering ultimately upon registration. His answer was 15 to 20. Director Sterling, how many do we have?
Sir, last count, we have 107.
We have 107. And even if you consolidated the 5 largest financial institutions in the United States, which have 37 combined, Bank of America has 7 registered swap dealers, Morgan Stanley has 10 registered swap dealers, Citibank has 4, Goldman Sachs has 13 registered swap dealers, Jpmorgan has 3. That would bring that total roughly to 70, correct?
Yes, sir.
Okay, so I discussed this before in the context of the swap dealer de minimis discussion. That's a 350% margin of error, which may cut it for Washington, but I think in the projection industry in the real world may not be sufficient. So I think there needs to be an honest discussion about how many entities we are currently regulating, how many entities we should be regulating, and how far we need to go abroad to apply our own rules, CFTC rules, in the regulation of entities that have some connection to the United States. Now, I think the language of 2I is very important. A direct and significant connection with activities in the United States or direct and significant effect on commerce of the United States. There's been a lot of discussion around the word activities, and that if there is some connection to activities, therefore it should be considered significant or direct. I'm not exactly sure. Do we have a measurement of activities in the United States? What does that mean?
Activities in the United States?
How much activity is there in the United States?
Well, I think there's a lot of activity in the United States, not to put too fine a point on it.
Yeah, okay, but we have a measure of commerce.
Sure.
We have GDP.
Oh,
for
yeah,
instance.
that's massive, sir.
We have market capitalization of firms. We have an understanding of revenues across the private sector. So we can either focus on some generic unmeasurable construct like activities, or we can look at other language in 2I, a direct and significant effect on commerce of the United States. I think it's reasonable to consider both, but I think it's more reasonable to focus on something we have measurements of so that we can make sure we're applying our resources abroad in an appropriate way. And even domestically, I think, in recognition of other regulators. There was some discussion about the Federal Reserve. The Federal Reserve supervises bank holding companies, correct?
Yes.
Do you know how many pages the bank holding company supervisory manual is?
I don't have a count on that, sir.
It's 1,800.
Yeah.
Do Do you know how many times it references the word swap?
I do not.
I have them marked
Excellent.
220 times. That this manual references the word swap in connection with prudential regulation over bank holding companies. So while I appreciate the fact that our rules may be designed in different ways and there may be different components of what we do, the activities of a bank holding company on a consolidated basis are regulated by the Federal Reserve. Even despite that fact, we still have an aggregation principle across subsidiaries, correct?
Yes.
So that you look at across all the activity of all subsidiaries, and if it's over $8 billion, one of those subsidiaries has to register with us, correct? In terms of dealing with U.S. persons.
Yes.
So maybe one final question. Do you know how many foreign consolidated subsidiaries exist in the world of U.S. financial institutions?
No, I do not.
Do you think it's in the hundreds?
I would venture to say it's probably higher than that, but I don't know.
I think it's in the thousands.
Okay.
Considering there was some estimate that there would be 15 to 20 swap dealers originally registered, and a foreign consolidated subsidiary prong would stretch our extraterritorial application of CFTC rules into the thousands, I'm not sure that's appropriate. Let me leave it there until we have our own second round of questions, Mr. Chairman. But let me also just say that I'm very appreciative of the hard work of my staff, Peter Calls, Margot Bailey, and Kevin Webb, for their hard work over the last 4 weeks since we originally got this rule to look into it, as well as the countless discussions we've had with you and your staff, especially Matt Dagler, over the last number of months.
Thank you. No, and I want to make clear, all of the staffs, as Commissioner Benham said, as Commissioner Berkovitz said, contributed to this. I think everybody didn't get everything they wanted, but this does have a lot of input into it, and I think it is a really important issue. As you can see, it's obviously, wouldn't say controversial, but there are divergent views, because it is where, as Commissioner Berkovitz said in the very beginning, we're trying to get that balance right, and we may fall on different sides of that balance, but this really is a question. Just to put things in perspective, because I think people watching this are wondering, what are we talking about? We are talking about, just a sort of a yes or no, we're talking about transactions that occur overseas, where there are two foreign persons. They may be related to a U.S. person back here, but that's what we're talking about.
Yes, Mr. Chairman.
Right. And right now, we have guidance. And that guidance, there's no legal requirement that market participants actually abide by the guidance, though we understand most of them are. Is that right?
Yes, sir.
Okay. One question I had was, I think Commissioner Berkovitz raised the issue, well, the guarantee. So we have tweaked the definition of the guarantee, and I think that's something we've asked people to comment on. We've got to be able to get that right. Has the SEC, my understanding, though, is that our definition is the same as the SEC's definition in their final rule, which they're approving right now. Is that right?
So I don't have the SEC's final rule in front of me, but I think that understanding is correct.
Okay. And not that we do everything and follow the SEC blindly, but so they have agreed on that standard as well. So
right.
There is something to be said, I think, about having a similar. And if we were to take, I guess, let's take not the 2013 guidance, but the 2016 proposal. And one of the questions I asked is, if we were to universalize that, what would that mean for our banks operating here in the United States? In other words, if we went with the 2016 proposal, made it law, and every other jurisdiction in the G20 did so, what would that mean for would everybody be regulating everyone else effectively then?
I think so.
Okay. So that is something you thought about when you were constructing this rule, is what would make sense sort of on an international basis?
Oh, yes, Mr. Chairman, absolutely. We considered that the world has changed significantly in terms of where other jurisdictions' requirements are since 2013, looking at the comparability requirements, and that gave us comfort that an approach like this was one we felt good recommending.
Now, the reliance on the Federal Reserve, and I was a banking lawyer for a decade, so I'm well familiar with Regulation K, Part A of which deals with U.S. operations overseas. There's a clear statement there that banks need to, their overseas subsidiaries and branches need to conform to the same high standards. But I am concerned, I think, by the issue that Commissioner Berkovitz raised about the London Whale and other things, and that may say more about our counterparts, but they've been working on that since then. But weren't those trades in the London Whale case cleared, centrally cleared?
Yes.
Okay, so we would have that information. Is that correct?
Sir, yes.
And as would the Fed. And then secondly, when that happened, however many years ago it was, the UK has the Financial Conduct Authority as well as the PRA, the Prudential Regulatory Authority. Are you familiar, do they have margin rules now similar to we do, as well as swap dealer-like requirements?
Yes, and we found them comparable.
Okay, all right. That's all I have, all my questions for now. Before we go to the next round of questioning, we'll start with Commissioner Berkovitz. You again, I have to entertain a motion to adopt the rule before us, so we can consider it and then vote on it. So could I have someone second the motion?
Second.
Thank you. Okay. So let's go ahead to our next round of questioning. Commissioner Berkovitz.
Thank you, Mr. Chairman. First, let me just agree totally with what Commissioner Benham's line of questioning was regarding that change Monday night. And we had the discussion, we had a productive meeting last week. I met with the team. And one of my questions then, and it's my belief, I've said this consistently over the years, I support codification of the guidance. If people want the guidance to be binding, I'm fine with that. The guidance really is how we interpret it. It doesn't tell other people what to do. It's our interpretation and how we are going to enforce the statute. It's hard for somebody I mean, they could engage in activity that we would find inconsistent with the guidance. We can't bring an enforcement action on that basis because it's not binding. But okay, if people want binding guidance, let's codify it and give it some certainty. That's okay. I don't have a problem with that. What concerns me, and what we talked about last week in our meeting was, I'm fine with codifying the guidance. If the intent of this commission is to put this out for notice and comment and then codify it, I'm supportive of that. What I'm hesitant of, we got this guidance the first time around, there's a lot of criticism of the guidance. Our interpretation of 2I at the time was believed way out there. It was too far out. We were expanding our jurisdiction. You go back in the record and look at the comments when we put the guidance out for comment the first time. That's a lot of the comment we got. We've got criticized over this guidance over the years as being too expansive in our jurisdictional reach. So given that, we're putting it out for comment yet again. I mean, we'll get the comments. I mean, that's fine. I'm not afraid of comments, but I think realistically, there's going to be a lot of critical comments saying your interpretation is wrong. 2I doesn't stretch as far as you want, and therefore, one response of this commission might be to pull back and not go far as we did in 2013. And that's why that statement that's in there now that was changed 2 days ago in what our fundamental interpretation of 2I is, where we said, initially the draft said the commission, the change from direct and significant connection was to necessary to address risk and resiliency is concerning, because that is a much narrower interpretation. In exercising a supervisory authority outside the United States, however, the commission will do so only as necessary to address risk to the resiliency and integrity of the U.S. financial system. As necessary to address risk to the resiliency and integrity of the financial system. That's what this says, only where we will exercise our jurisdiction. The statute says has the direct and significant connection standard. So this, as Commissioner Benham pointed out, is a fundamentally different standard than we've been using. So that raises my concern that we're actually not codifying the guidance. We're pulling back our cross-border jurisdiction based on some risk and resiliency test, and then we adopt the risk and resiliency test, and we say, well, that's what the prudential regulators do, so why do we need to do anything? Risk and resiliency to the financial system is covered by prudential regulation, so what do we need our regulations for? That's where my fundamental concern on this. Let me I want to ask some specific questions about the significant risk subsidiary. And I have a graphic that I've constructed to help me understand the flow. And I take full responsibility for any errors in here. I'm not going to hold the team accountable or to verify this or anything like that. But and it's actually probably too small for everybody to read. So it sort of defeats the purpose in that it's small. But the first test for a significant risk subsidiary is whether the parent has greater than $50 billion in consolidated assets. And by my ability to figure out what that meant, implication, the information that I pulled off the web, actually if you do a Google search for 50 billion consolidated assets, there's actually a study by Better Markets that comes up that says there's 38 entities that meet that threshold. It's used in other financial regulations. So we're talking about 38 entities here. Then you get to various tests for whether the subsidiary is significant. If it meets if the parent meets the $50 billion threshold, there's 3 tests. Equity capital test, which has to do with a 3-year rolling average of percentage of equity of the subsidiary in relation to the parent. Similarly, a 3-year rolling average of revenue of the subsidiary compared to the parent, and assets, similar type test. If it doesn't meet any of those tests, it's not a significant risk subsidiary. In other words, if the subsidiary is a small enough percentage of the parent, it's not a significant subsidiary. If it meets any of those tests, it's considered a significant subsidiary, but that doesn't mean it gets regulated. Okay? If there is prudential regulation in the US, I think there was a discussion on that. If there's a prudential regulator, it doesn't qualify as a significant risk subsidiary. Or if there's comparable non-US capital and margin rules in a non-US jurisdiction where it's not subject to prudential regulation, then it's not a significant risk subsidiary. The cost-benefit analysis on this says, more precisely than what I've got here on this box, the cost-benefit analysis says, quote, few if any, unquote. That's correct? Few if any would meet all these tests and become a significant risk subsidiary?
That's what we said for cost-benefit analysis purposes, sir. And what I would say is I haven't had an opportunity, you'll forgive me, to review. I have no reason to agree or disagree with the study you found. The idea is to try and identify under both prongs of 2I potential where risk could arise that otherwise would not be on our radar from a rules perspective. And we tried to draw with this proposal reasonable lines around wherein and at what level we should look. And I must thank Commissioner Quintenzi. He articulated it much better than I as we think about a direct or significant effect, if you will, or connection to U.S. commerce. We do consider the size of U.S. commerce. And so starting the winnowing down or focusing, if you will, we thought 50 billion as referenced in other financial regulations would make great sense for that.
Okay, thank you. So I have a question about the application of this comparable non-U.S. capital and margin standard determining whether an entity is in a jurisdiction that has comparable non-U.S. capital margin rules. And let me read something from the proposal. I'm reading on page 58 of my text. And this was the Monday evening text. I don't think it probably changed substantially, but for purposes of determining whether proposed 2323A12(2), little I2, and that's the comparable non-U.S. capital margin rule standard, would apply, the Commission intends for persons to independently assess whether they reside in a jurisdiction that has capital standards that are consistent with Basel III. So who's making the test on whether they're in a comparable jurisdiction? Is they make it, or we make it, or they make it and we oversee? Who's making the test whether they're in there's comparable non-U.S. capital and margin rule jurisdiction?
Right, well, I'd invite input from my chief counsel on this, but I think the commission, sir, has made comparability determinations in these areas, and I think it's therefore incumbent on people with knowledge of our rules to understand that and ascertain whether they find their subsidiary in such jurisdiction.
Well, it says they reside in a jurisdiction that has capital standards that are consistent with Basel III. That's
And we do ask a question about whether that is an appropriate test, and whether we should add
whether
some
we
rule
should be the
text.
one who, whether we should
Or
be the one
whether
who
whether
picks-
we can articulate a more standard that's more objective.
Okay. It seems to me that we should be the one determining whether in jurisdictions who, if they have certain rules, then they don't have to follow our rules, rather than say, oh, I'm in a jurisdiction that has comparable capital rules, therefore I don't have to follow your rules. I would feel a lot more comfortable if we made that determination. On the test whether there's prudential regulation, if there's prudential regulation, then we are, I don't know what the proper word is, deferring to the prudential regulators, or they're not called a significant risk subsidiary because presumably there's sufficient prudential regulation. In this case, the Commission preliminarily believes deference to the foreign regulatory regime would be appropriate because the swap activity is occurring within an organization that is under the umbrella of U.S. prudential regulation with certain regulatory protections already in place. So we've got some degree of comfort that because it's prudentially regulated, we don't have to regulate.
In the context of looking towards the outer bounds under 2I, yes, that's right. We made the decision in recommending something for the Commission's consideration and public comment ultimately that a prudentially regulated subsidiary, or a prudentially regulated U.S. entity that has a subsidiary subject to consolidated supervision is not a place we would need to go to apply our swaps requirements overseas.
Well, let's put this in perspective. These are significant risk subsidiaries. These are the big subsidiaries that pose significant risks. Mm-hmm. These are the most risky of those overseas bank organizations. These are the most risky affiliates. They're the biggest subsidiaries, and there's $50 billion in the parent. So and the risk is coming back. And that's the situation we're going to defer to the prudential regulators in.
What we're saying is, yeah, the size of the subsidiary would be large in relation to the parent. The parent itself large. The parent itself is bank regulated, and I wish I'd had the snap count that Commissioner Quintens did, but through 200 codicils and 1,800 pages of regulation, we feel pretty good at that point that inasmuch as the activities themselves are essentially offshore, that yes, the banking regulators are exercising an appropriate degree of supervision over that. That's our sense of it, sir.
Right, but the banking activities are offshore, but it's coming back to the U.S. because it's consolidated. It's a parent, it's consolidated, and the entity, it's a significant subsidiary of a U.S. parent. So if something happens, it's going to come back to the U.S. and it's prudentially regulated, and it's those big risky entities. The biggest risky entities are the ones we're going to be deferring to the prudential regulators on. Or the non-U.S. as long as there's capital and margin. And I have a fundamental problem with deferring to the prudential regulators. I know I've got tremendous respect for the prudential regulators in certain respects. And I know that, you know, they've covered what they have to cover. But the fact is, the only reason we're all in this room debating this is because they got it wrong. Okay, there was a crisis because the prudential regulators got it wrong. Greenspan concedes error on regulation. Okay, the modern risk management paradigm held sway for decades, he said, Greenspan. The whole intellectual evidence, however, collapsed in the summer of last year. Bernanke, and there's quotes up and down through 2005, 2006, 2007, couldn't see any risk from that the housing issue was not a national issue. He didn't see any national risk for this. Greenspan, Bernanke, the prudential regulators got it wrong, fundamentally got it wrong. And we had a financial crisis largely for that reason. Now, should they have gotten it right? Is it in the power of, you know, any individual to have omnipotence about what's going to happen in the future? No, I mean, I don't necessarily blame them for getting it wrong. Sure. And Bernanke did a great job in helping address it. But the fact is, what Congress did in response to that was not just beef up prudential regulation. It said we also want market regulation. And they put in Title VII in the Dodd-Frank Act, in addition to Title II and Title III. We have a whole title of directing us to regulate activities because Congress didn't believe prudential regulation of these entities was sufficient. And that's why we're here today. That's what we do. That's why we have 23-600. That's all the Jpmorgan whale things. That's what the enforcement order said. And that's what we're directed to do. And for us now to say, oh, well, it's prudentially regulated, everything's fixed. Now we can trust the prudential regulators. I find inconsistent with our direction in Title VII, at least where we've got the balance. I mean, I'm happy if you want to respond to that, or it's not a question, but if you want to respond, feel free to.
Oh, I was only going to say I appreciate your observations and thoughts on that. We understand them, and I would just only reiterate, if I may, that we have a very robust and complete, the commissions prior to voted on it, set of regulations that apply to banks dealers and dealing activity here. We apply our requirements on a cross-border basis. Significant risk subsidiary was an effort to identify potential pockets of activity that would not otherwise be captured in some meaningful way. And we did draw a line there, and we look forward to public comment on it. And it just is like we appreciate your observations today, so thank you for that.
Yeah, let me just also trot out some other ancient history, but it's not so ancient. And this was the first time that this agency tried to regulate the OTC market in the 90s, and that result was a disaster. And ultimately, I think in wake of the financial crisis, people recognized that Congress's action in the CFMA and the action of the prudential regulators to squash this agency's attempt to exercise jurisdiction in these markets was a mistake. But let me read you what they said back then. The report of the President's Working Group on Financial Markets, the Treasury, the Federal Reserve, the SEC, and Chairman Bill Rayner, CFTC chairman, was on this report too after Brooks Lee Bourne was effectively removed from the scene. This august group said back then, one of the reasons why CFTC didn't need to regulate these markets. First reason was sophisticated counterparties that use derivatives don't need this regulation. In addition, most of the dealers in the swaps market are either affiliated with broker-dealers or FCMs that are regulated by the SEC or the CFTC, or are financial institutions that are subject to supervision by bank regulatory agencies. Accordingly, the activities of most derivatives dealers are already subject to direct or indirect federal oversight. And that was the reason in 1999 to prohibit us from regulating over-the-counter derivatives, that these are already overseen by bank regulatory agencies and the SEC and others. And that rationale was a fundamental mistake in 1999 when we had a financial crisis, and Congress changed that. I just have to add here, and a point when reading this document. It goes on. And this is how wrong people can be. I mean, nobody's the repository of perfect knowledge. We aren't, they aren't. That's why we have multiple agencies regulating these activities now, not just one. But the next sentence, believe it or not, says, most OTC derivatives are not subject to manipulation. Okay? Thus, for example, it is highly unlikely that interest rate swaps could be used to manipulate interest rates. Now, technically, that may be correct, and what happened was interest rates were used to manipulate interest rate swaps, but they said interest rate markets couldn't be manipulated, okay? And we're proud to have with us today, okay, and all the prudential regulators of all that. And Mr. Chairman, and you're going, I know you've got to get to a meeting, and we issued a release today on this very issue. Who was the first agency? Who was the leader? Who was the leader? Who was the global leader in fixing the LIBOR problem? Okay? I mean, which agency took the lead on that? And who do we have here today? You know, Vince McGonigal. Vince, okay? Read the Spider Network, okay, about the story about the LIBOR investigation and what this agency did, and Vince reading the Wall Street Journal article, and Vince going to talk to Gretchen Lowe and bringing it up the chain, okay, and this agency taking the global lead, okay, and exposing LIBOR and fixing that global market, okay, we are and have been for a decade more a global leader in all these markets. And we can't just simply defer to the prudential regulators. We have a robust enforcement program. We have a robust regulatory program. We're on a level playing field with all these regulators now. We're not subservient to prudential regulators like we used to be 10, 15 years ago when everything in this world was mother may I with the prudential regulators. I have full respect for them, okay? They keep our banking system safe and sound, okay? But we have our role, and I'm not going to defer to them and say, we don't need our risk management processes and procedures for affiliates of our banks overseas because they're all prudentially regulated. So fundamentally, I'm a very strong proponent of the CFTC and our jurisdiction, and I don't want to see us back off our rule that Congress mandated. So thank you.
Thank you, sir. And if I may, just by way of conclusion, your remarks, which I greatly appreciate, I just want to say that certainly in putting together this recommendation and working with several in this building, and we also like Vince a lot too, by no means do we mean to create a roadmap for prior crises or oversights to arise. I think, as you said towards the beginning of your first round of remarks, we're trying to draw a reasonable line looking at the swap regulation regime that's been stood up under the world, under the G20 regime, where indeed we were the first movers. We continue to be at the vanguard of regulation in this area. And in a particular space where we wouldn't per se apply our dealing requirements right now, we made a decision that banking regulators that now take a macroprudential approach, because it's changed in the last 10 years too, can have a lead, and that's all we've said. So I certainly thank you for your observations, and just wanted to assure you that in thinking through these areas, not only were we mindful of the prior financial crisis, we'll feel comfortable that we're not seeking to lay the seeds for it to repeat itself. Thank you.
Yeah, thank you. And just one final thing in that we have made a lot of progress with the margin requirements, the capital requirements, and clearing. I've said it many times, and I'll say it again. The financial world is safer today because of our actions, because of the other regulators' actions, and because of the industry. But we have to be very careful about this time is different syndrome, and to be thinking here today that we've solved it all and it's now all safe, and we don't need to be vigilant, and this agency doesn't need to be vigilant anymore because everything is safe. We can't go that far.
Thank you very much, Commissioner Berkovitz. Commissioner Stump?
I just want to follow up on the last points that were made. I agree. The CFTC has often been the global leader and often been unrecognized for being the global leader in many regards. But that said, we can be the global leader, but we don't seek global dominance. And I want to point out that in 1999, perhaps we relied too heavily on the prudential regulators. But today, we're not only relying on the prudential regulators, but in oftentimes jurisdictions have comparable market regulations that are being applied. And we're talking about a set of dealers and potential dealers in foreign jurisdictions that are regulated by their market regulators as well as overseen as part of a bank holding company under our prudential regulations. Is that accurate?
Madam Commissioner, that's correct.
Okay, thanks. And while we're talking about this, I just have a few questions with regard to this new concept, significant risk subsidiary. I think we can all go back to whether we're codifying the guidance or we're improving upon the guidance. There was this concept in the guidance that no one's talked about yet of affiliate conduits. And it was very confusing. And we're trying to, today, put on the table something for the public to weigh in on that is an alternative to that. But I just have a few questions about how we got here. Is it fair to say that both affiliate conduits and significant risk subsidiaries are designed to get at a universe of entities that have some type of connection to the U.S. interstate commerce, and we have to consider whether that should be brought into the CFTC swap dealer regulation, but it is in addition to U.S. persons and those guaranteed entities that are already going to be captured under this proposal?
Madam Commissioner, that's correct.
Okay, so this is in addition to U.S. persons and guaranteed affiliates. So when we talk about that narrow universe of people and the fact that conduit affiliates was extremely confusing, and in fact, it wasn't even defined in the guidance. It was the result of a set of factors that people were supposed to interpret and try to understand and come to some conclusion as to whether or not they were in fact a conduit affiliate. So today, we're trying to put in place more clarity by having measurable, quantifiable metrics around this concept of significant risk subsidiary. Is that right?
That's correct. Bright line percentages and numbers and so forth.
Which should frankly lead to better compliance and more enforceable rules. So if the objective here is for people to comply, and if they don't, for us to enforce our rules, it stands to reason that a quantifiable, objective metric is the right approach, as opposed to what previously was included in the guidance, which was a set of factors that I'm sure every banking entity in the world spent bazillions of dollars on legal fees trying to determine if in fact they were captured under any of these factors. You don't have to answer, Josh.
Well, I do agree.
So, in my opinion, this may or may not be the right path forward, but we're putting this out for comment to ask the public if in fact it makes sense. Because what we've learned in the last 6 years is that conduit affiliates was confusing. In 2016, in an attempt by Chairman Massad to put forward a proposal to codify the guidance, the concept of foreign consolidated subsidiary was introduced. That was confusing in this context. And so now we're simply putting on the table something else for the public to consider as we attempt to get this rule to a place that makes sense in capturing entities in addition to U.S. persons and guaranteed affiliates. It's not as though we're creating a loophole you can drive a truck through. We're capturing all of these other folks already. So I just wanted to point that out because the conversation is fascinating. I think it's going to be more fascinating once the public has an opportunity to weigh in on something that they've never had the chance to consider. And so we are just providing another alternative to those things that have been put on the table previously. We're not finalizing anything today. Just a couple of other questions, and Commissioner Benham and Commissioner Quintens talked a little bit about the number of swap dealers that have been registered with the CFTC. So there are 107, but approximately how many of those are located outside the United States?
So there are approximately 60 that are outside the U.S., so just over half.
Okay. To your numbers, have those numbers remained relatively constant, with approximately half of them located outside the United States over the course of the provisionally registered swap dealer regime that we put in place?
Yes, I think that's a fair statement. Since the end of 2014, there have been approximately 90 or more registered swap dealers, with approximately half outside the United States.
And would you expect to see a significant number of those currently provisionally registered swap dealers withdraw from registration under this proposal?
We do not, though we do ask questions about it.
It's fascinating that today over half of the swap dealers registered with a United States market regulator are not located in the United States. That's all the questions I have.
Thank you very much, Commissioner Stump. Commissioner Benham?
No questions, but I do want to reiterate and support Commissioner Stump's comments about this being obviously a proposal, and for all of us in the room, for all of you, and thank you again for all your work, and those listening understand the distinction between a proposal and a final. Although I've articulated my concerns with this, and we've had a pretty robust back and forth, I do appreciate your team and your effort to be objective in the questions we ask and to take a pretty holistic approach to what the next step is on this rule. It's extremely important, and Commissioner Berkovitz pointed out, obviously, the history, which I talk a little bit about in my statement, and why we're here and what we need to do going forward as a regulator and as policymakers and as a country. And I look forward to those responses. So thank you again.
Thank you very much, Commissioner Benham. Commissioner Quintens?
Maybe just a couple quick questions to wrap up or put a few things in context. There was some discussion about the London whale and the CIO losses in April and May of 2012. Director Stilling, do you know how much money Jpmorgan made in the second quarter of 2012?
I don't.
They made $5 billion in 2012. So the $4 billion of losses by the CIO did not affect their profitability.
Right.
So, I mean, I think that while that activity was concerning, it was also designed as a hedge for Europe blowing up, which it almost did. I was in the markets during that period. There was significant risk to the global financial system at that point. While it was, in my view, a very poorly constructed hedge, and I think Jpmorgan, through its own report, admitted that, it was nevertheless designed as a hedge. And in my own experience as an investment manager, maybe not to this degree, but I think you always want to lose money on your hedges because they're designed to lose money. So I'd like to put into context the Jpmorgan whale event in terms of anyone's suspicion that it threatened the bank or the U.S. financial system as a whole. Along those lines, do we have, when, I appreciate this chart, I think it is very helpful. When we're looking at the concept of a significant risk subsidiary, it isn't the case that none exist, but it may be the case that a number exist, but they're all regulated by the Federal Reserve or a prudential regulatory authority abroad. Is that a possibility?
It certainly is, sir.
So even if there are no residual significant risk subsidiaries, that doesn't mean that none exist, and because they would already be regulated at the prudential level. And I think it is important, and I'll get to this in my comments. I think that this is an important test because what we're talking about is the risk to commerce or activity, however we define that in that general concept, in the United States of a foreign entity dealing to foreign counterparts. If they're dealing to the United States and to U.S. persons, our rules already capture that through de minimis tests. But what threat does a foreign entity dealing to foreign participants pose to the U.S.? There has to be some measure of significance to the U.S. financial system or U.S. commerce in terms of the limiting authority that Congress put on our agency. And I think that this is a well-designed test that captures the significance of the parent in terms of its size, that captures the significance of a subsidiary in terms of its size, and that respects the jurisdiction of the Federal Reserve or other foreign regulators. So I compliment you and your staff on the work on this product. Thank you, Mr. Chairman.
Thank you. Just some final questions. Fraud and Manipulation Authority. nothing in this rule changes or somehow reduces our authority to prosecute fraud and manipulation. Is that right?
That's correct, sir, and I did consult with leadership in the Division of Enforcement who I believe share that view.
Okay, so this is focused on registration and supervision as swap dealers.
Yes, Mr. Chairman.
So I appreciate Commissioner Berkowitz's recounting the tale of the Clinton years and this commission's fight. I will say, however, in the number one, I think, again, many of those arguments had to do with domestic markets. And again, this rule is focused on overseas activities only. Is that correct?
That's exactly right.
Okay. Do we have and many of the things I agree with Commissioner Berkowitz, but Congress did make some fundamental choices in Dodd-Frank. I was in the Senate Banking Committee at the time. Does the CFTC promulgate the regulations covering margin and capital requirements for insured depository institutions or banks that are swap dealers?
No, sir.
No. So Congress clearly gave that authority to them. Congress also sort of removed a provision that was called Fed Light, which disallowed the Federal Reserve as consolidated supervisor to sort of defer to regulators such as us, and particularly the SEC. They gave essentially the Fed the power to override market regulators like us that were, regulating subsidiaries. And you may or may not be aware of that. Are you?
Yes, sir, I recall
Yes.
that, yes.
Yes. So there is something, I think, that prudential regulators have and supervisors today that we don't have. The other thing I would ask you is do you think the international framework for derivatives regulation has changed since 10 years ago?
I can state with absolute conviction that yes, it has.
So pretty much everybody is required to apply the same rules and regulations.
That's
Similar.
right. Yes, sir, under the
Okay.
G20.
So does this recognize that as well?
It certainly does, sir.
Okay, and I would agree with Commissioner Berkowitz that we need to make that comparability determinations, or at least rely on the Federal Reserve or something if we're talking about Basel rules. I will not vote for anything that allows an individual institution to say, well, we're in Macau and they have similar rules and regulations, and therefore we're out of this thing. So I just want to make that clear. I think that's a good point. And it'll be interesting to see what commenters say, but that is my position.
No, we certainly would agree with you, sir.
Okay. So with that, why don't we go ahead and turn to any closing statements people would like to make? Go ahead, Commissioner Berkowitz.
Thank you, Mr. Chairman, and I made many of the points that I had in my statement, and so I'm not going to read the whole statement. I just want to make 2 points. One is I'm very concerned about the relaxation of the guarantee, combined with, and we haven't had discussion on this here, and I'm not going to start it now, about the A&E, the arrange, negotiate, execute. I'm very concerned that by relaxing the guarantee test, that this will enable U.S. affiliate, or the non-U.S. affiliates of the U.S. banks to potentially deregister as swap dealers, because they won't have the guarantee tie requiring them to register. They'll reduce a non-U.S. A U.S. bank with many non-U.S. affiliates may concentrate all of its U.S.-facing swap activity in one of those foreign affiliates. The other affiliates would not be required to register. It could do all of its outward-facing swaps in those non-registered, non-U.S. affiliates, use its New York offices for booking, or not for booking, use those New York offices for the personnel, conduct activities out of New York, simply book it in one of these other locations, and conduct a lot of swap dealing activity out of entities that are, in non-registered entities that are currently registered. That is a potential I see from the relaxation of the test for guarantee, which I would, if there's a way to prevent that from happening, love to work with you on that as we go through and get the comments, but that's one of the concerns I have on this. And I just want to rather than go through my prepared remarks, which will be on the web, I appreciated the comments from Commissioner Quintens, because I think your comments highlight the difference in viewpoint between your views and where I'm coming from on this. And some of that is in the other issue, which we highlighted in the way that the test is worded, and a lot of this proposal reads, the jurisdictional test, that we're only going to exercise jurisdiction when we believe there's a significant risk to the U.S. financial system. Okay, that's one thing that and Jpmorgan and the London whale, did Jpmorgan's $4 billion loss threaten the financial system? So does that mean we have a lesser interest in it, or what is our interest in it? If it doesn't threaten the financial system, is that something we should be concerned about, or should only be concerned about these larger things that we consider risks? And you've set up the test for significant risk subsidiary. Only if we believe that there's significant risk are we going to regulate the activity. And here's what my concern about that reasoning is. We don't know what the significant risks are. Sometimes it's clear and they stare us in the face. And this goes to the quotes I was reading from about Greenspan and Bernanke. Even the best of us don't know what the risks are. And it's not that there was anything wrong with the analysis, or, well, I guess there was things wrong with the analysis, but it's you have the best and the brightest basically not knowing what the risks are. So if we adopt a risk-based test, I mean, we are not going to get all the risks. And there are examples. Long-term capital management I don't think long-term capital management would have popped up on any of these screens. We had 2 Nobel Prize winners advising long-term capital management. You think if they thought that they were engaging in incredibly risky activity, they would have gone ahead and done it? They didn't think they were betting the company or potentially setting a cascade in effect that would affect the entire financial system. Nobody did. I mean, so you have Nobel Prize winners who can't see what these risks are out in the future. Bear Stearns. Nobody would have thought that the Bear Stearns hedge funds that were collapsing were systemically important, but they turned out to be very systemically important. And sometimes risks that aren't systemically important set in motion these cascading events of a loss of confidence and set forth other people selling or doing what. So you just don't always know what the big risks are. And if you focus only on risks that you know are large, you're going to miss some. And that's what we did in 2008. We missed those. So what do? What the Congress set forth was an activities-based test as well. So that's why we have risk management procedures in these institutions, so that they manage all types of risks. You just don't say, well, there's a big risk, I'm going to manage it. You have processes and procedures to make sure people think these things through carefully. So I believe, based on activities, and the significant risk subsidiary doesn't have any swap activity test in it. It's all on bigness, okay? There's nothing about their swap activity in there. I would much rather focus on the swap activity, and if you engage in certain swap activities, then you come within our purview. It's not solely a risk-based focus, and I don't think we should solely pay so much deference to other regulators. All these risks are going to come back to the U.S. taxpayer, and ultimately, the one difference between us and the other jurisdictions is a question was asked about, well, what if all the countries in the world did this? Okay, well, one distinction between us and all the other countries in the world is we're the ultimate financial backstop for the entire world. That's what we were in 2007 and 2008. It was our Federal Reserve not only bailed out our U.S. banks, our overseas affiliates, foreign banks in the U.S., but our Federal Reserve, $4.5 trillion worth of credit to foreign central banks so they could bail out their banks. We were the ultimate backstop on the world. And I think that gives us some say in how the regulations go around the world, different from other countries as well. So thank you. I appreciate being able to discuss these in an open meeting. I think it's healthy, and I appreciate your commitment to openness and being able to discuss these in public meetings. So I thank you.
Thank you very much, Commissioner Berkowitz. Commissioner Stone.
Thank you. I just wanted to point out again, our intent in issuing this proposal is, or at least my intent, is not to sweep even a greater number of potential global dealing activity within our jurisdiction, nor is it to enable a significant number of those currently registered swap dealers to withdraw from registration. Rather, the intent is to attempt to codify the guidance into a rule set. But we would be remiss if we didn't make the improvements we know need to be made. We've learned a lot in the past 6 years, and some aspects of the guidance that lacked clarity. I think that this proposal sets forth our attempt to obtain input from the public on whether or not we've made the rule set clearer than it was perhaps in previous proposals. With regard to this conversation about risk, I think that I should take some credit for the change that was made that's caused all of the controversy. But I would also say that risk may not necessarily be the only thing we need to consider, so I am open to taking out the word only. But the reality is that in interpreting 2I, risk is to the financial system is something that we do consider. And previous leadership of this commission, notably Chairman Gary Gensler, repeatedly told me when I was working on Capitol Hill at the time that we needed to focus on risk washing on to U.S. shores. So we have to take into consideration, especially in the context of this rule, whether the risk that is potentially coming back to the United States. And so I do think including the words here are important. I was somewhat skeptical, I should admit to this too, of a restatement of the 2I analysis from the guidance, and I want to make very clear that as we go forward, I do not consider it to be precedent setting. The application of the 2I elements that are contained in this the preamble to this rule are not something I will intend to be held to as we go forward. But I do appreciate the inclusion of the risk element. So it is also somewhat ironic that I would today be supporting any codification of the guidance, because I was sitting in this room in 2013 when the guidance was discussed, and I shared the view vividly articulated by then Commissioner Jill Summers that the guidance, as it has been proposed, reflected what could only be called the Intergalactic Commerce Clause of the United States Constitution. Had I been a commissioner at that time, at the time the final guidance was issued, I likely would have voted against it. But the question before us today is not whether the guidance was the right thing to do at the time, but what the right thing to do now is. So much has changed since then. We have now implemented nearly the entire swap regulatory regime called for under the Dodd-Frank Act, and many of our fellow regulators around the world have implemented commensurate reforms. Since the guidance was issued, the CFTC has issued 11 comparability determinations regarding the regulation of swap dealers in the European Union, Canada, Japan, Australia, Hong Kong, and Switzerland. And it is also appropriate to acknowledge the tremendous resources that market participants have devoted to compliance in the wake of the guidance, which they should not have to endure again absent a demonstration that the guidance is not working. Based upon our experience during these intervening years, we are now able to transform the guidance into actual regulation. I believe the guidance was always intended to be temporary, and so today I see our role as updating and improving upon the guidance as we seek to codify it, such that it is finally enforceable. Thank you, Mr. Chairman.
Thank you very much. Commissioner Benham.
Thanks, Mr. Chairman. I'll respectfully dissent from the Commission's notice to proposed rulemaking addressing the cross-border application of the registration thresholds and certain requirements applicable to swap dealers and major swap participants. Support the Commission's effort to make good on its commitment to periodically review its approach to evaluating the circumstances under which the swaps provisions of Title VII of Dodd-Frank ought to apply to swap dealing and related activities outside of the United States. Indeed, the guidance currently in place in Section 2I of the Commodity Exchange Act itself provide the Commission the flexibility to evaluate its approach on a case-by-case basis, affording interested and affected parties the opportunity to present facts and circumstances that would inform the Commission's application of the relevant substantive Title VII provisions in each circumstance. Today, the Commission is proposing to discard both the existing guidance and the use of agency guidance and non-binding policy statements altogether in addressing the cross-border reach of its authority in favor of hard and fast rules. I simply do not believe the Commission has made a strong enough case for wholesale abandonment of guidance at this point in the evolution of our global swaps markets, and in light of current events that are already impacting market participants and their view of the future global swaps landscape. As well, I have serious concerns and questions as to what the Commission may give up should the proposal be codified in its current form. Whereas the Commission understands the scope of our jurisdictional reach with respect to Title VII, a federal district court has confirmed that understanding, and we have operated within such boundaries. Aware of the risks and successfully responding in kind, the Commission is now making a decision based on the most current thinking that we should retreat under a banner of comedy and focus, only on that which can fit on the head of a pin. Oddly enough, that pin will hold only the giants of the swaps market. Indeed, where our jurisdiction stands on its own, the ability to exercise our authority through adjudication and enforcement has allowed the Commission to articulate policy fluidly, refining our approach as circumstances change without the risk of running afoul of our mandate. Today's proposal suggests that we can resolve all complexities in one fell swoop if we alter our lens, abandon our long-standing and literal interpretation of 2I, and limit ourselves to a purely risk-based approach. I cannot support an approach that would limit our jurisdiction and consequently oversight directly in conflict with congressional intent and potentially expose the U.S. to systemic risk. Throughout the preamble, the proposal evinces a clear understanding that the complexity of swaps markets, transactions, corporate structures, and market participants create channels through which swaps-related risks warrant our attention by meeting the jurisdictional nexus described in 2I. However, in many circumstances, we manage to simply acknowledge the obvious risk and step aside in favor of the easier solution of doing nothing, assuming that the U.S. prudential regulators will act on our behalf, or waving the comedy banner. The proposal provides shorthand rationales for each of its decision points without the support of data or direct experience, as if doing so would reveal the vision's vulnerabilities. Perhaps most concerning are the proposal's contracted definitions of U.S. person and guarantee, its introduction of substantial risk subsidiaries, and its determination that A&E means something akin to absolutely nothing to explain. These represent some notable examples where the proposal undermines the core protections sought to be addressed in 2I, as the Commission has until now understood them to be. My concerns aside for a moment, I am grateful that within the four corners of the document, the requests for comments seek to build consensus and operatively provide the public an option to maintain the status quo with regard to most aspects of the guidance, albeit without sticking with guidance. While this leads me to more questions as to whether and how the proposal could go final absent additional intervening process, I am pleased that there is recognition that the public and market participants may have lost their appetite for this brand of rulemaking, or perhaps have come to agree with the D.C. District Court that the Commission's decision to issue the guidance benefits market participants. Further, as the Commission currently engages with our foreign counterparts regarding impending regulatory matters related to Brexit, I hope we are measured in timing and substance on this proposal. Before I highlight certain aspects of the proposal, which I won't, Mr. Chairman, because I'll keep this brief, I want to take a brief moment to acknowledge why, as a general matter, we are here and why this particular proposal is so important. Without rehashing market realities that led to the economic devastation of 2008, it should be never lost on our collective consciousness that a significant driving force that exacerbated the financial crisis and Great Recession, at least within the context of OTC derivatives, was housed overseas. Although much of the risk completed its journey within the continental U.S., it was conjured up in foreign jurisdiction. But as we all know too well, more than 10 years later, despite the products often being constructed, sold, and traded overseas, the highly complex web of relationships between holding companies, subsidiaries, affiliates, and the like created a perfect storm that brought our financial markets to a near halt and the global economy to a shudder. Those experiences should always serve as the foundation from which we craft cross-border derivatives policy. Despite my concerns regarding this proposal, I look forward to hearing constructive input from market participants and the public. I am encouraged by the balanced nature of the requests for comment and would like to modestly request that in responding to the proposal, commenters indicate whether they believe it is appropriate and prudent for the Commission to proceed with the rulemaking at this time, or whether the preference is to adhere to the current guidance or some hybrid of the two. As with all rulemakings, input the Commission receives through the public comment process drives the conversation and sets us on a course that balances diverse interests, seeks transparency, resiliency, and efficiency, and above all else, focuses on protecting U.S. markets, its participants, and most importantly, the customers that rely on this truly global marketplace. One might assume that making targeted surgical changes to an existing regulatory framework is easier than creating a framework, but in some circumstances, it's exactly the opposite. Global swaps markets have grown and evolved over rule sets that were completed and implemented in the very recent past. As regulators, I believe we should caution against any wholesale rewrite when we find well-regulated, transparent, and generally well-running financial markets. But if we do find vulnerabilities or inefficiencies in our rules, certainly both old and new, the process to reconsider should be deliberate, balanced, and inclusive to ensure the Commission, as a collective body, understands the gravity of its decisions. Mr. Chairman, I'll reserve the rest of my comments given the time constraints. They will be published in whole. Again, thanks to you and, of course, Director Sterling and the team for this work. I certainly look forward to working with you in the future. Thanks.
Thank you very much, Commissioner Benham. Commissioner Quinten.
Thank you, Mr. Chairman. Let me thank again the staff from DSIO for all of your hard work on this, as well as you, Mr. Chairman, and your office and your team, and my team, as I had thanked before. I'm very pleased to support today's proposed rule, which in my view delineates important boundaries of the Commission's regulation of swaps activity conducted abroad, which would codify elements of the 2013 interpretive guidance and make important adjustments with the benefit of 6 years of additional experience in swaps market oversight. Congress deliberately placed a clear and strong limitation on the CFTC's extraterritorial overreach, recognizing the need for international comity and deference in a global swaps market. I believe the proposal strikes a strong balance in interpreting Section 2I of the CEA. The proposal before us would interpret it in ways that provide both important safeguards to the U.S. financial markets, as well as avoid duplicative regulation or disadvantage U.S. commercial and financial institutions acting in foreign markets. Let me also say that I appreciate the comments of all of my colleagues, and I agree with Commissioner Berkovitz that our discussion has, I think, really shown our own philosophical perspectives as well as our analysis of the facts and of history. I believe that risk exists everywhere and at all times, and I think the question for us is how much of it and in which locations we need to apply our regulations particularly and uniquely. I think in the context of that risk as existing abroad, and even in the context of here at home, we have a de minimis threshold under which risk exists, but we have made the decision, some of it I don't support, but we've made this decision that the cost and the benefit of the regulations shouldn't apply under a certain amount of swaps dealing risk. In terms of the risk that exists abroad, I think there's a difference between risk generally, which, as I said, exists everywhere and at all times, substantial risk, significant risk, which we're trying to get a framework around, and then systemic risk, which everyone at all times is concerned about, and which I think we have a multi-layered approach to in the United States and globally. Let me also raise some comments around the tests for the significant risk subsidiary. I think that the 3 tests proposed are very interesting. I think they do a good job of trying to limit our reach, but I am very interested in other ideas for tests that could get at different risks or, to the United States, as long as it's not based on notional value. That'd be fine with me. And long-term capital management was brought up, and I just wanted to highlight something in the rule because I thought it was it struck out at me that in our definition of a U.S. person, we're ensuring that if the management of a fund is done in the United States, we consider that entity a U.S. person. So this definition would actually have captured long-term capital management, even though I think it was organized overseas officially. But beyond that, long-term capital management had $4 billion of equity, which they levered up through loans to $100 billion, which they then used to buy or deal $1 trillion worth of derivatives. I'm pretty sure that even without our U.S. person definition, we would have caught that entity through all of the other regulations and regulatory constructs that we have. And I think we need to view all of these things holistically and not try to take them apart as representing our entire framework individually. Let me leave it there, Mr. Chairman, and thank you again for the time you dedicated to this proposal and to all of my commissioners for their comments.
Thank you very much. I mean, just in closing, I would say, look, when I approach this, I think about a few things. First is I do think we need some finality to this. It's been, 2020 will mark 10 years since the Dodd-Frank Act, and I do think we need a regulation that is binding on all those to whom it applies, as opposed to just sort of guidance. The other thing is, and I can't stress this enough about what we're talking about, is here we're not talking about dealing with U.S. persons. We're literally talking about swaps activity that occurs outside the U.S., where the counterparties are outside the United States. So then we asked ourselves the question, well, what outside activities should trigger registration and requirements? Now, Congress gave us a clear directive, or I should say they gave us a directive. It's clear that there may be some differences in interpretation, but they basically said, look, Title VII does not apply outside the United States, except in two circumstances. Number one, where there's a direct and significant connection with activities in the United States and interstate commerce, and secondly, basically where those activities can be used to evade Title VII. So this proposal, I think, tries to strike that balance. It's neither a intergalactic commerce clause, nor is it a totally isolationist mentality. And personally, when I think about this and when I approach this proposed rule, I had sort of three guiding principles. The first was protect the national interest. The important role of the CFTC is to think about the United States and our interest. And for me, that means U.S. taxpayers. We don't want to have a framework that incentivizes risks to come back that ultimately leads to bailouts. The second thing I thought about is, look, we also are taxpayer funded. So we have to focus primarily on our markets, our participants, the things where they need the CFTC the most, and we can't be out regulating things in far-flung lands that don't present risk to U.S. taxpayers. That's not a good use of taxpayer money. So we're trying to sort of get that right. And in thinking about this, I asked the question, well, is there a significant risk out there? And if so, is there anybody else looking at it? And if the answer is yes and no, there's a significant risk and no one else is on the case, then I think it's incumbent upon us under 2I to go after that. And so the significant risk concept, subsidiary concept, basically says, look, is this something that's potentially a risk to U.S. taxpayers, something somebody needs to be looking at? And then if we say yes, then we say, well, is the Federal Reserve required to look after that under their consolidated supervision, under the Bank Holding Company Act and that entire regime? If the answer is yes, okay, we've got someone on that. Then we say, for a subsidiary overseas, do they have the same capital and margin requirements that we do here in the United States? If another overseas regulator is looking at it, okay, then we're not. If there is, though, a Enron subsidiary that they created, let's say, overseas, it's not subject to Federal Reserve requirements. It's not subject to any, let's say it's in an offshore tax haven thing and they're doing swaps activity, then we basically treat them the same as if they were sitting here in Washington doing that activity, because that's a potential risk. So that's really what it's focused on. So the first principle is the U.S. national interest. Second is, I rarely bring up a 18th century philosopher, but Immanuel Kant, his famous categorical imperative. When any time we're dealing with foreign activities, how much should we regulate abroad? I ask the question, if we took what we're going to do and we universalized it, what would be the result? And if you have a situation where we're regulating everything overseas, external activities, and every jurisdiction in the G20 did the same thing, we would end up with everybody regulating everyone else, and the end result would be absurdity. So I think my view on this is basically we afford comity to other regulators. If their institutions are here in the United States, they play by our rules. If our institutions are over there, they play by their rules, assuming they have those rules. And if they don't have rules comparable to us, then again, if it rises to the level of being significant, and no one else's, our fellow domestic regulators are not looking at it, we're going to focus on that. And then the third principle, anytime we're dealing with the swaps realm, is harmonization with the SEC. In the jurisdictional fight over swaps, some of us were there on the Hill in different committees during the Dodd-Frank Act. Basically, Congress split the baby. They said, well, CFTC, you take swaps. SEC, you take securities-based swaps. That has a long lineage for decades in other areas of the law. We have about 95%, I think, of the swaps market. But they also directed the two agencies to work together, to coordinate, to harmonize where possible. Simple enough? Wrong. We couldn't even agree on the definition of a U.S. person. And a U.S. person is not something that is distinct or particular to financial regulation. So I think this makes a stride in that regard, where we finally define U.S. person the same way. But as my colleagues have said on many occasions, we're also not just going to blindly follow the SEC. So we have departed from their view on arranged, negotiated, and executed, because I think our markets are very different from their markets are. And instead, we focus on the significant risk subsidiary to get at a risk such as a potential Enron that would Enron around our laws and regulations. And so I think this is a really great proposal. I thank the staff for all of the work. I look forward to the comment period, to continued discussion among the commission, and I think it's a really important that we get this done. I would just end by a quote by President Eisenhower in his farewell address. He said, "The world must learn to work together, or finally it will not work at all." I think this is a step forward in the right direction in working with our domestic and international counterparts, and I hope this will be a step towards making our global swaps market subject to even greater sound regulation. So thank you very much. Now I ask the question, are the commissioners prepared to vote?
Yes.
Okay. So, Mr. Kirkpatrick, will you please call the roll for the proposed amendments to Part 23 of the Commission's rules?
Thank you, Mr. Chairman. The motion now before the Commission is on the approval of the proposed rule making amendments to Part 23 of the Commission's rules. Commissioner Berkovitz?
No.
Commissioner Berkovitz votes no. Commissioner Stump?
Aye.
Commissioner Stump votes aye. Commissioner Benham?
No.
Commissioner Benham votes no. Commissioner Quintens?
Aye.
Commissioner Quintens votes aye. Chairman Tarbert?
Aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 3, the noes have 2.
Thank you very much. The ayes have it, and the motion to support the motion is hereby approved by the Commission. Given that we have had a robust discussion and a really good one, what I would propose is whether we can have a quick 10-minute break for people to, for number one, the new team to come up to the table, for those of us that need a quick 10 minutes, and then we will reconvene.
If the Commission is agreeable, yes.
Yes. Okay. We will take a 10-minute intermission. Okay, well, welcome back, everyone. At this time, I'd like to invite a second staff presentation on a proposal to amend Part 37 of the Commission's rules. The proposed rule would prohibit the practice of post-trade name give-up for swaps that are executed anonymously on a CEF and intended to be cleared. From the Division of Market Oversight, we have Vince McGonigal and Aleko Stimoulis. Pleasure to have you both with us today. Please go ahead and begin.
Thank you, Mr. Chairman. I'll turn it over to Aleko, who's taking.
Thank you, Mr. Chairman and Commissioners. Thanks for the opportunity to present the staff recommendation that the Commission approve a notice of proposed rulemaking relating to post-trade name give-up on swap execution facilities. So this proposal is to amend Part 37 of the Commission's regulations in order to prohibit the practice of post-trade name give-up for cleared swaps. The term post-trade name give-up refers to a practice whereby the identities of swap counterparties are disclosed to one another after a trade is executed anonymously. The proposed regulation would prohibit a CEF from directly or indirectly, including through third-party service provider, disclosing the identity of a counterparty to a swap if the swap is executed anonymously and intended to be cleared.
The proposed regulation would also require CEFs to establish and enforce rules that would prohibit any person from making such a disclosure. The prohibition would only apply to those CEFs that facilitate anonymous trading of cleared swaps. So otherwise, all named disclosed execution methods for both cleared and uncleared swaps would still be permitted. And post-trade name give-up would also continue to be permitted for uncleared swaps. This proposal has been made after considering public comments received in response to a request for comment on the practice of post-trade name give-up that was published by the Commission in November of last year. Both prior to and through the public comment process, market participants have expressed views that post-trade name give-up deters some market participants from trading on CEFs that employ the practice, thereby limiting participation and competition on these CEFs. By this recommendation for proposed rule, the Commission would consider whether prohibiting post-trade name give-up for cleared swaps would promote additional swaps trading on CEFs, as well as promote fair competition among market participants. Two statutory objectives provided under the Commodity Exchange Act. Encouraging a greater number and more diverse set of market participants to anonymously post bids and offers on these affected CEFs may promote greater interaction and competition, which should allow these platforms to act as more efficient mechanisms for price discovery. So furthermore, pursuant to the Commodity Exchange Act and Commission's regulations, swap data repositories are already prohibited from disclosing the identities of cleared swap counterparties. Allowing CEFs to disclose counterparty names diminishes the purpose of prohibiting access to this information at an SDR. Prohibiting post-trade name give-up on CEFs, therefore, would help to advance the objectives underlying the statutory privacy protections applicable to SDRs and the Commission's implementing regulations. Finally, the practice of post-trade name give-up for cleared swaps may be inconsistent with the requirement that CEFs provide market participants with impartial access to trading on their markets. Post-trade name give-up may be undermining the policy goals of impartial access, which the Commission has stated are to ensure that market participants can compete on a level playing field and to allow additional liquidity providers to participate on CEFs. Prohibiting post-trade name give-up for cleared swaps may better fulfill these goals. This concludes our opening remarks. This time, we're happy to answer any questions on the proposal. Thank you.
Thank you very much, Aleko, and thank you, Vince, for your leadership on this. To begin the Commission's discussion and consideration of the rulemaking, I now entertain a motion to adopt the proposed rules amending Part 37.
So moved. Second.
Thank you very much. I'd now like to open the floor for commissioners to give any statements and ask questions in order of seniority, so I'll go ahead and begin. I'll begin by stating that Commissioners Berkovitz, Benham, and I have worked on a joint statement that I think represents our views, and it was a pleasure to work with you and your staff on that joint statement. So that'll be posted on the Commission's website, and let me just briefly say that I agree with the proposal. I think it does really two things consistent with what you just said, Aleko. Number one, I think it will attract more participants to CEFs and a diverse array. And secondly, I think it promotes fair competition among market participants. So again, we have a joint statement on this proposal. I look forward to reviewing the comments on the proposal and working with all external stakeholders to address this issue in a way that enhances liquidity, ensures impartial access, and promotes and increases fair competition. Commissioner Quintens.
Thank you, Mr. Chairman. I have a couple questions, and then I'll try to go through my statement quickly. Are there particular types of swaps transactions that trade predominantly or maybe even exclusively on interdealer platforms? It's my understanding that spread over spread trades are almost exclusively traded on interdealer CEFs. Is that your understanding?
Yeah, we're aware of data provided by market participants in the past. It indicates that spread overs make up a significant, in many cases, majority portion of trades executed on interdealer CEFs, while they make up a much smaller percentage of trades on dealer-to-client platforms. So, yes.
Okay, and does staff or does the proposal express any concern about the potential impact that banning this practice could have on the ability of market participants or dealers to actually execute those trades?
The proposal does specifically ask for comment regarding whether and how prohibition on post-trade name give-up should apply to package transactions. So we definitely encourage market participants to comment on this and include any relevant information relating to how trading and spreads might be affected. So yes.
Okay, thank you. And has the commission done its own analysis of the average pricing on dealer-to-dealer versus dealer-to-client CEFs? And is that information the commission would be able to analyze if it hasn't done it yet and incorporate into a final rule?
So I'm not aware of a study done within the commission that specifically and directly compares prices between dealer-to-dealer and dealer-client CEFs. However, the proposal does specifically request comment and additional information on this issue. And for example, how prices on for swaps on order books compare to those on disclosed RFQs, which are more commonly used in the dealer-client space, and how post-trade name give-up relates to that. So
Okay.
we're looking forward to learning more about that.
Okay, thank you. I would like to pay particular close attention to any comments that come in on that or any analysis that's done by the commission. I think there's a perception that pricing is better on certain platforms than others, or certain categories of platforms than others. So to the extent that the commission can analyze that issue using our own internal SDR data and leveraging off what the commenters provide us, I think that would be important for us to consider in any final rule. So, Mr. Chairman, with your permission, I'll maybe just run through my statement real quick. I'm going to vote in favor of today's proposal to prohibit post-trade name give-up practices for swaps that are anonymously executed on a CEF and cleared, in order for the commission to receive further comment on the proposal's potential market structure impact. As was already described, in November 2018, the commission issued a request for public comment regarding the practice of post-trade name give-up, which I supported. The overwhelming majority of comment letters to that release opposed post-trade name give-up and requested the commission explicitly prohibit the practice. And the proposal before us today was heavily informed by those commenters' perspectives. This proposal rightly notes that for anonymously executed and cleared trades, the need for market participants to know the identity of their counterparties for credit risk, legal, or operational purposes was obviated by the central clearing of swaps. However, I have concerns about the government banning an established trading practice that has supported liquidity in a marketplace and serves a market function. That market function is to enhance swap dealers' own risk management needs resulting from their clients' exposures. And while I am very sympathetic to arguments around promoting fair competition, and I think that that is a strong mandate and something with which I would like to align myself, it gives me great pause to consider something that the government would mandate a change to a market structure in the hopes of increasing competition and liquidity, but perhaps without fully understanding how those changes may implicate fundamental market dynamics. So let me leave it there, Mr. Chairman, and just say that I am going to support the proposal today, but I'm going to pay very close attention to both the comment letters and our own internal analysis in my consideration of any final rule. And I'd like to thank Vince and Aleko for your hard work and DMO generally. Thank you.
Thank you very much, Commissioner Quintens. Commissioner Bennett.
Thanks, Mr. Chairman. First, thank you, Aleko and Vince, for your work on this. And also pleased to join you, Mr. Chairman, and Commissioner Berkovitz in a concurrent statement. Certainly when we have the opportunity, I think it serves us all well in the commission above all else. I have no formal comments or questions immediately, but I certainly, above all else, look forward to the comments. I think a lot to Commissioner Quintens's point, a lot of the information that we can glean from internal data, SDR and otherwise, will be helpful in sort of the process as we move toward a final rule. Above all else, I think this proposal is consistent with Dodd-Frank, with Title VII, and many things I've said in the past, specifically thinking about just a little bit over a year ago when we proposed the CEF rule of promoting healthy markets, liquidity, certainly impartial access, as you pointed out, Aleko. These are key fundamentals of the Dodd-Frank trade execution requirement and vision for what the OTC swaps market would become. So I think this is a step in the right direction, but certainly look forward to comments from market participants and the public to the extent that they're willing to weigh in, and look forward to moving forward on this rule. Thank you.
Thank you very much, Commissioner Benham. Commissioner Stump.
I just have a few questions. One, just in the context of the central limit order book, which is when we talk about post-trade name give up, that's the sharing of the name of the counterparty after the trade is executed anonymously. So the concept of anonymous execution applies to one of several execution methods known as the fully anonymous central limit order book. We're not getting rid of any other execution methods here, but when we talk about the liquidity to date in the central limit order book, it's been minimal compared to the other methods of execution. Is that correct?
It does depend somewhat on asset class, but generally yes. So for IRS in particular, in the dealer client space, for example, trade volume is predominantly through disclosed RFQ, not anonymous order book. And with respect to the fully anonymous CLOBs in particular, anonymous execution and no post-trade name give up, we don't see a lot of volume on purely electronic and fully anonymous CLOB.
So while the existing requirement to offer CLOB for required transactions may have been a little more prescriptive than I would have liked years ago when the CEF rules were adopted, the reality is that by providing a choice, we've given the marketplace the ability to choose where they want, in what sort of forms they want to transact. But what we're really contemplating here, I think, is a bit of a chicken and egg concern with regard to the liquidity on the CLOB and the practicality of the CLOB structure that subscribes to pre- and post-trade anonymity for cleared swaps. In that very narrow context, I think there's a fundamental question here that's being overlooked. Does the market require more demand for pre- and post-trade anonymity to incentivize liquidity, or does it need more liquidity to incentivize pre- and post-trade anonymity? It's a little bit of an unfair question, but I'd love to hear your thoughts.
Yeah, it's an interesting point, Commissioner Stump, and I think we look forward to the comments in addressing that point and generally market structure issues, and I think that those will be an important part of informing the Commission and staff on a final rule.
Yeah. I look forward to the comments also. I think this point gets lost sometimes when we talk about customer choice, but the reality is there's very little liquidity in this space, and we don't know why that is. So I think that's fundamental to us being able to move forward in finalizing this rule. My other questions are really more about trade processing and protocols, and I just wanted to ask how the proposal deals with package transactions, where some elements are cleared and some are not.
So yes, the proposal does specifically raise this issue. Post-trade name give up, the proposal acknowledges could be necessary for certain cleared swaps that are components of packages in particular, where the package includes an uncleared component. So there is a question in the proposal requesting additional public comment, on the necessity and the scope of, an exception for package transactions.
Okay. And I just wanted to take the opportunity to encourage commenters' input on how the proposed prohibition on post-trade name give-up affects trading protocols such as auctions, portfolio compression, and workup sessions. I think you offer including a question on that. I think that's very important here, that we have a conversation about what the implications are. And then I just wanted to make sure I understood correctly. The proposal supports the prohibition by referencing SDR privacy regulations. Am I understanding correctly the assertion here that allowing post-trade name give-ups on the back end at a SEF renders moot another CFTC rule for SDR prohibiting one party from accessing the identity of their counterparty under swap data reporting rules?
Yeah, there is a SDR regulation that would prohibit, counterparty name disclosure at the SDR level. So what the proposal says is that, post-trade name give-up may undercut the intent of this requirement and the congressional objectives underlying the statutory privacy protections in the CEA for SDRs.
Okay, thank you. So just a very brief statement. I've said it many times that building a new market structure for swap trading and execution on top of the legacy market that existed prior to enactment of Dodd-Frank is a challenge and one we are expected to fulfill under the Act, and no one said it would be easy. We know what Congress's stated goals for establishing SEFs are, and they're fairly simple: to promote the trading of swaps and swap execution facilities, and to promote pre-trade price transparency in swap markets. We also know, as evidenced by the recent request for comments on the practice of post-trade name give-up, that there are diverse viewpoints as to what prohibiting the practice will do to the episodic nature of the swaps trading, the depth of the book, bid-offer spreads, and execution costs for market participants. However, unlike in 2010 when the Dodd-Frank Act was passed and provided us with this authority, and in 2013 when the Commission finalized Part 37 regulations, we now have the benefit of data that could assist the public in justifying all of these divergent viewpoints. Unfortunately, other than the CFTC, no one is privy to what transpires across the entire SEF market structure. So I will support this proposal. I think it's very well-timed and it's important, but I also believe that the Office of the Chief Economist should produce a publicly available study aggregating and anonymizing the market data for publication, such that everyone can ascertain the overall incentives and interests that inform customers, dealers, and liquidity providers' willingness to achieve the congressionally mandated goals of promoting trading of swaps on swap execution facilities. This will enable more informed dialogue with market participants going forward. Congress entrusted us to achieve the specific goals of promoting swap trading on SEFs, and I assume they also expected us to preserve the ability of market participants to transfer risk using swaps. Our challenge is finding the appropriate market structure to achieve both. SEFs were not intended to be a club, nor were they intended to be casinos. So I look forward to all of the comments. I think it's going to be quite a challenge to digest them and reconcile the divergent comments we are expected to get on this one. But I support putting the proposal out. Thank you.
Thank you very much, Commissioner Stump. Commissioner Berkovitz.
Thank you, Mr. Chairman, and I sincerely thank you for putting forth this proposal. I was very pleased to join in the joint statement with you and Commissioner Benham on this, and I'm really applaud your leadership in putting forth this proposal. This is something that I've been very interested in since I came onto the commission, and been supportive of as we've considered other proposals for improving our trading regulations. So I'm very glad to see this proposal put forward today, and largely for the reasons that you've noted, to get a level playing field. Under a post-trade name give-up, one side to the transaction has information advantage knowing knowing the trading of the counterparty, and generally that's not the case on anonymous trading. I also look forward to the questions. There's already a number of economic analyses, economic papers on this. There's our experience with other markets, but we don't have experience in our markets on it because we still have on the prohibition, because we still have the practice. So I just want to focus on some of the questions, ask questions about the questions, if I may. So the preamble, there's a number of questions in the preamble, and some of them have been discussed by my colleagues here today, including on how the proposed rule would impact liquidity on the SEFs. For example, question 4 in the preamble asks, How would the proposed prohibition on post-trade name give up affect existing liquidity on CEFs? How would the proposed prohibition affect liquidity on central limit order books? Would the proposed prohibition directly affect liquidity on name disclosed request for quote systems? If so, how? In particular, please provide substantiating data, statistics, and any other quantifiable information related to such comments. Well, I think that's, all those questions are important. How would the prohibition affect liquidity? But we don't, this is asking for how would. Do we, how would there be data on something that doesn't exist? We can't expect hard data for people's projections of what would happen if this were to happen, correct? We don't have experience in name give up. We don't have data on trading where the practice is prohibited, right? Or do we?
No, that's correct. You know, the data would be useful in providing perhaps a snapshot of the current market structure, but yes, I agree with your premise that it wouldn't be so predictive. The cost-benefit analysis included in the proposed rule does talk about some studies of other markets, but not the swaps market, and our markets are unique. So,
right.
Yeah.
Appreciate it. So my only just caution here is that ultimately, end of the day, how this rule would affect liquidity will be somewhat, we'll have to make a judgment based on various market participants and academics and whoever's commenting and inputting, and our chief economist, whoever weighs in on, you know, whoever either weighs in on it or we can call in as a resource and get their views as to what might happen if this rule, whether in fact this rule will benefit. And I look forward to considering all the comments and all the viewpoints on how this rule would work. I just want to caution we may not get hard data because it's asking for something that doesn't occur yet. So we'll do that, and I look forward to that. And we also consider whatever comments on the other issues that you asked for as well, too. So with that, I definitely support going forward with this. I would also just say that in all these market structure things, we had the issue recently of the asymmetric speed bump that one exchange wanted to impose an asymmetric speed bump to promote liquidity. And I think there were different views on that issue, as well as to whether in fact that would attract liquidity, be detrimental to liquidity. The goal I think everybody has is to get liquidity in our markets, and it's just a question of how we do it. These market structure issues are difficult. As Commissioner Stump said, it's a chicken and an egg. You don't know whether the change will help things or not because you can't run a trial experiment necessarily when you change your rules. So anyway, look forward to the comments on it. Thank you very much.
Thank you, and I'd like to pick up on something both Commissioner Stump, but particularly Commissioner Berkovitz said. You know, we're dealing with a counterfactual here. So, you know, the way I look at it is we have a general principle, and we've applied it in our exchange-traded markets and other markets, that if it starts off anonymous, it remains anonymous. Prior to the clearing requirement, there was a need for post-name trade give-up because of counterparty credit risk. But we've eliminated that now, but yet this practice still stands. And so in many ways, the principle, we'll see whether it is vindicated if the proposed rule becomes a final rule. And then we'll obviously study it thereafter to consider, you know, what the effects are. But with that, are the commissioners prepared to vote? Okay. Well, Mr. Kirkpatrick, would you please call the roll for the proposed amendments to Part 37 of the Commission's rules?
Thank you, Mr. Chairman. The motion now before the Commission is on the approval of the proposed rule on amendments to Part 37 of the Commission's rules. Commissioner Berkovitz?
Yes.
Commissioner Berkovitz votes yes. Commissioner Stump?
Aye.
Commissioner Stump votes aye. Commissioner Benham?
Aye.
Commissioner Benham votes aye. Commissioner Quintens?
Aye.
Commissioner Quintens votes aye. Chairman Tarbert?
Aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 5, the noes have 0.
Well, it is unanimous. The ayes have it, and the motion to adopt the proposed rule is approved. Thank you so much for presenting. At this time, I'd like to invite a third staff presentation on a final rule amending Part 39 of the Commission's rules for derivative clearing organizations. So we started off with DSIO, we then went to DMO, and now our third major policymaking Division of Clearing and Risk, will present. From DCR, we have Clark Hutchison, Eileen Donovan, and Parisa Abadi. Thank you so much for joining us. You may begin when ready.
There we go. Thank you, Mr. Chairman. Good morning, Commissioners, fellow staff. On May 16th of this year, the Commission proposed and sought comments on amendments to the provisions of Part 39 of the Commission's regulations that pertain to derivatives clearing organizations. Today, the staff and I will present a final rule to Part 39. The Commission received 14 substantive comments from market participants and the public, and we feel that this final rule given to you today reflects a fair balance of those comments. So with that, and in the deference of time, I'll turn this over to Parisa. Parisa.
Thank you, Clark. Good afternoon, Chairman and Commissioners. As Clark stated, staff is presenting today a final rule for the Commission's consideration, amending Part 39 of the Commission's regulations. Part 39 implements the statutory core principles for DCOs. Since Part 39 was adopted in 2011, staff of the Division of Clearing and Risk had been keeping track of issues with the regulations, including provisions that needed further interpretation or clarification, inconsistent procedures, and provisions that didn't reflect actual practice. So this rulemaking was really meant to clean up the regulations and address those issues identified. Because the rulemaking covers a range of topics under Part 39, I'll focus on some of the key highlights of the rulemaking, including where the staff recommendation in the final rule differs from the proposal. At the time Part 39 was adopted, the Commission had one registered DCO that cleared fully collateralized positions for which many of the requirements would not apply. For example, margin and default procedures. This was addressed at the time through staff relief, but with the addition of other registered DCOs that clear only fully collateralized positions, this rulemaking will carve them out of the requirements that are inapplicable. In addition to the changes that were proposed, staff is recommending that the Commission adopt a few other changes related to fully collateralized positions that were suggested by commenters. The Part 39 regulations already require DCOs to manage various types of risks, but some DCOs lack a formal program to address those risks on an enterprise-wide basis. A DCO will now be required to have an enterprise risk management program and to identify as its enterprise risk officer an appropriate individual that exercises the full responsibility and authority to manage the DCO's enterprise risk management function. Whereas the regulation was silent before, DCOs will now be required to calculate their largest financial exposure net of required margin on deposit rather than total margin on deposit, including excess. This is a change that will bring CFTC regulations into line with international standards on this issue. The Part 39 regulations currently provide that a DCO must require its clearing members to collect initial margin from their customers for non-hedge positions at a level that is greater than 100% of the DCO's initial margin requirements with respect to each product and swap portfolio. Before this requirement was implemented in 2012, several DCOs noted that, as written, it would actually require DCOs to significantly increase margin requirements for certain types of customers, for example, non-clearing futures commission merchants, or FCMs, which are typically charged the same initial margin as clearing FCMs. At the time, staff issued interpretive guidance that gave DCOs greater flexibility in determining to which category of customers the higher margin would apply. The rule is now being amended consistent with this interpretive guidance, with additional edits suggested by commenters for further clarification. In response to a recent default at a CCP outside of the Commission's jurisdiction,
The Commission proposed a number of changes to its regulations on DCO default management, DCO default rules and procedures. First, the Commission proposed to require that a DCO include clearing members in a test of its default management plan. Staff is recommending that this change be adopted but modified to require clearing member participation in testing of the plan only to the extent that the plan relies on the participation of clearing members as suggested by commenters. The Commission also proposed to require DCOs to provide immediate public notice of a default. Due to concerns about the potential market impact of providing immediate notice, staff is recommending that the timing of the notice be left to DCOs, but that notice be given as quickly as possible, taking into account the potential negative impact it might have on the DCO's ability to manage the default. Lastly, the Commission proposed to require that a DCO establish a default committee in the event of a default involving substantial or complex positions to help identify any market issues that the DCO is considering. In light of strong divergence in the views expressed in the comments on this proposal, staff is recommending that the change not be adopted at this time. Staff believes it would be appropriate to give industry stakeholders some time to come closer to consensus on this issue. As the Commission is aware, a designated contract market or a swap execution facility is required to submit a certification to the Commission prior to listing a product for trading that has not been approved under Regulation 40.3. However, DCOs are not required to provide any notice to the Commission before clearing new products. As a result, the Commission had proposed to require a DCO to provide notice to the Commission no later than 30 days prior to accepting a new product for clearing. Due to many objections raised by commenters, staff is recommending that this change not be adopted at this time and the issue be revisited in a future rulemaking. And finally, in 2011, the Commission proposed but never finalized rules addressing core principles O, P, and Q relating to governance fitness standards, conflicts of interest, and composition of governing boards. The Commission subsequently adopted rules for systemically important DCOs and Subpart C DCOs in this area that are consistent with the principles for financial market infrastructures, but there are DCOs to which they do not apply. Therefore, the Commission proposed to make these requirements applicable to all DCOs. Staff recommends that these changes be adopted largely as proposed. This concludes the overview of the rulemaking. We're happy to answer any questions you have.
Thank you very much for that excellent presentation. Thank you, Clark. Thank you, Eileen, but particularly Parisa. Thank you so much. I've seen you here late at night burning the midnight oil with you and your staff to get this done. To begin the Commission's discussion and consideration of the rulemaking, I'll now entertain a motion to adopt the final rules amending Part 39.
So moved.
Second.
Thank you. I'd now like to open the floor for commissioners to ask questions and give statements. We'll go in reverse order of seniority this time. Commissioner Berkovitz.
Thank you, Mr. Chairman. I have no questions. I'll give a statement, and I want to thank the staff, Director Hutchison, Parisa, and Eileen. We met last week. It was a very helpful meeting to help us walk through this rule. The shortness of the presentation and the lack of controversy on this rule really masks the tremendous amount of work that went into it. It's not a simple, this is not a simple rule that's being finalized. It's very technical, and there's a lot of technical aspects to it that are being codified and changed and accumulating all these changes over the years and putting them in rule form and clarifying it, and that's excellent work, and I want to thank you for it. I support the final rule to amend Part 39 of our regulations for derivative clearing organizations. This Part 39 codifies 18 core principles and related regulations with which a DCO must comply to obtain and maintain its registration status. Part 39 also provides additional standards for systemically important DCOs, SIDCOs. Clearing of futures, options on futures, and swaps at commission-registered DCOs is a key pillar supporting responsible derivatives risk management. The G20 leaders recognized the benefits of central clearing when they adopted central clearing of swaps as a key global response to the 2008 financial crisis. In the United States, Congress enacted a swaps clearing mandate in the Commodity Exchange Act and establish SIDCOs as a higher regulatory tier for large DCOs as determined by the Financial Stability Oversight Council. Maintaining strong DCOs through effective risk management and regulation is critical to the safety of derivatives markets and to preventing another financial crisis. The final rule for Part 39 that we have before us is an example, a good example, of how the Commission can make tailored amendments to improve the clarity of its regulations and codify staff guidance and relief that has accumulated over time. The final rule updates the regulations without undermining the overall effectiveness and protective intent of the rules. In one area of note, the final rule does not codify the proposal to require DCOs to have a default committee with member participation and to convene the committee in the event of a substantial or complex default. The Commission received an array of comments on the proposal reflecting strongly held views both for and against the proposed changes. The preamble to the final rule notes the Commission's desire to provide the market with additional time to consider this issue with the goal of attaining a consensus of stakeholders. I look forward to continued engagement in this area. And this is the last rule that we'll be considering today and the last meeting for 2019. I again would like to thank all the staff that has presented today and that we worked with for the rules and generally on matters before the Commission. What we see today and do today and what the public sees is really just a small fraction of the really hard work and dedication that goes on. And even where we have controversial issues and even where we disagree, the public does not see all the areas that we've cleared out and we've resolved before those public meetings. So you're just seeing, it looks like, well, we're disagreeing on all these things and people aren't seeing where we agree. And that's true for a lot of this. So many of the issues go smoothly today and aren't discussed in public because we have been able to resolve them. So I want to thank the staff for working with my staff and my colleagues here. My staff has been working with your staff on all these rules and all these issues, and they're issues that weren't discussed today because they didn't rise to the level or they were resolved or otherwise taken care of. And so there's a lot of work that goes on behind the scenes, and I want to acknowledge that. I want to thank my own staff for all the work they've done over the past year to support what we do in my office. And there's just a tremendous amount of work behind the scenes that goes into these hearings, into the statements, and into that process, just putting up the charts and getting our information accurate and with proper analysis. So I want to thank my own staff, Eric Remler, Lucy Hines, and Sebastian Peugeot for all the great work that they've done this year and help for me and for the CFTC as a whole. So I'll thank everybody again and look forward to a new year where we'll get a little breather and then pick up. Thank you.
Thank you very much, Commissioner Berkovitz. Commissioner Stump.
I just echo everything everyone said in thanking you all, but I want to thank all three teams. It's kind of, I was sitting here thinking about the many times I've been briefed on the three topics we covered today by all three of the teams that presented today under different chairmen. Some of them, long before I got here, have been dealt with under 4 different chairmen. And the staff in all three of the divisions always exercise the most professional responses to the manner in which we prioritize things based upon who's leading the commission and the manner in which we choose to change things based upon who's leading the commission. So thank you all for sticking with us through, since in my time, 2 chairmen and 2 different sets of priorities. And in particular with regard to this rule, this team spent considerable time with me last summer when we proposed this rule, and I thank you for all of the work you did to further streamline it. I think it was probably obvious last summer that I had some concerns with regard to elements that were a bit more controversial. So I support moving forward in truly in advancing the less controversial items without disregarding the more controversial items. I assume we will continue to consider how we might address those, and I look forward to those conversations as well. I just have one question based upon some comments that came in. I understand that several commenters raised the concern with the proposed requirement that a DCO report to the commission on a daily basis margin, cash flow, and position information by individual customer account. Do DCOs currently report this sort of information to the CFTC?
Yes, they do.
So all we're doing here is codifying current practice.
That's right.
Okay. Does the final rule clarify what individual customer account means?
Yes, it does. It's a customer account.
Excellent.
Not the
Thank you.
beneficial owner, but the underlying customer account.
Great. I appreciate the clarity. Thank you.
Thank you very much, Commissioner Stump. Commissioner Benham.
Thanks, Mr. Chairman, and thanks to the team, Eileen and Clark, and especially Parisa for your work on this. Dan said it very appropriately that this is a bear of a rule, and it seems a lot simpler than it is, but the public should realize that it's a very complicated proposal or final rule that we're putting forth today, so I do appreciate all the time and work that's gone into it. And I appreciate, before I have just a few questions that we're considering, especially the default committee, very difficult issue. There's a lot of difficult issues in this space, and although we're not finalizing it or some others, I appreciate the fact that we're continuing to engage, continuing to think about these issues. They're very core challenges, I think, that we face as an agency and as a sort of community in the marketplace, where we do have very divergent views on how to move forward on it. But I think we can all agree that we want as transparent and safe markets as possible. The question is, how do we get there, and can we get there in an appropriate amount of time? So continue to look forward to those conversations. Regarding the specific text, I have a couple questions about market participants, specifically including a quote-unquote market participant on a DCO board. The proposal defines market participant, and I'm just wondering, how did we get there, and specifically the definition? And then if I'm not correct, and please do correct me if I'm wrong, we're not codifying that definition.
That's correct. In the proposal, because DCOs had asked for guidance as to how we would define market participants. So in the proposal, the idea was to limit market participants to clearing members or customers. And commenters pointed out that this would create certain challenges for certain DCOs. And for that reason, the preamble just states the Commission's expectation that a DCO would include customers on its board, but that's not a requirement now.
Okay. And are we distinguishing between customer representation versus market participant on the boards? And then what is our expectation sort of going forward with both of these?
So the statutory requirement in the core principle Q requires that they have market participants on the board. So that's a requirement. They have to have market participants. What we stopped short of is defining what is a market participant. We had proposed to define it as clearing member or customer, as Parisa said. Commenters raised issues that would create for them. For instance, we have several DCOs that only have retail participants. So they said, well, if we have to include customers, how would we decide which of them we would include? And so we stopped short of having the definition, but the preamble does indicate that we would expect a DCO to have customers. So I think we would see it as, presumably they should have them, and there would have to be a pretty good reason to not have them, but we did stop short of putting it actually in the rule as a requirement.
And then going forward, will we have any mechanism to sort of review whether or not there are customers in fact on the board, or are we just going to have this expectation that they do it in the future?
Well, I mean, we will be able to look at, they have to have market participants, so we would want to see who on their board they consider to be a market participant and who they are and why they made the choices they did, so yes. Yes.
Okay. That's all I have from questions. I appreciate those answers. I did prepare a statement that will be published on the website. It's not very long. So again, thank you to all three of you. And I think we're kind of wrapping up some things. I do want to Thank you, Mr. Chairman, for, you've been with us six months now, and it's been a very productive 6 months. We had a lot to do in the past month, so thank you and your staff, my fellow colleagues here, of course, and all three of the teams that presented today. It certainly was a busy month leading into today and as we look forward to 2020. And one thing I thought about this morning was this: we have a common theme about transparency has been coming up a lot, and I think that's critically important. We talked about it a bit at the last meeting, and we might disagree of sort of where this agency's come from, but I think we all agree that we need to be as transparent as possible going forward, and that manifests itself in public meetings, which I think are great for the commission and the public to understand and appreciate what we do on a day-to-day basis. Also, what we put on the website and what access we allow the public and market participants to see about this commission and this agency and the work that it does, the important work that it does. But I certainly hope that the other elements of transparency, the communication between the commissioners, between commissioners and the staff, can continue to grow, and we can improve on that in the future. The commissions are such unique bodies in the U.S. government, and we will all benefit from dialogue and discourse, despite the fact that we might disagree on many things. I think we all share the same common goals of, fulfilling our statutory mandate and doing our duties that we swore to, but of course, doing good by the market and the customers that we represent, and of course the taxpayers. And with that, I want to take a quick moment to thank my staff, above all else. Not unlike Commissioner Berkovitz mentioned, the amount of work that goes into these rules is tremendous. It's late nights, it's constant communications, it's weekends, and we all did that. So I want to recognize my Chief of Staff, David Gillers, who's not here today, but especially John Dunphy, my counsel, and Laura Gardy, who did a tremendous amount of work with the cross-border rule. So I couldn't have done anything without them, and it's been a great few years that I've been with them, and looking forward to 2020. Thank you, Mr. Chairman.
Thank you very much, Commissioner Benham, and it's been a pleasure to work with all of you. Commissioner Quintens.
Thank you, Mr. Chairman. I have a couple questions. At the risk of making me even more tardy to a prior speaking engagement, I feel like this is an important rule that I think deserves some targeted questions. I know this was issued as a proposal, I think, under the prior framework of Project KISS. I think it's even more streamlined now, so it's kissier or better. But it's I appreciate what we've been able to do and what you've been able to do in this rule. I had a quick question on cross-margining. The final rule requires a DCO that's seeking to implement or modify a cross-margining program with another clearinghouse to submit those rules for commission approval under 40.5. And the preamble to the rule points out that this requirement is based on the Commission's existing practices for approving cross-margining. Could you just quickly remind us how many cross-margining programs the Commission has approved since the adoption of the new Part 39 DCO rules in 2011, and how many clearinghouses have petitioned the Commission for cross-margining approval?
Sure, thank you. I'll go back to 1988. So from 1988 to the present, there have been 14 cross-margining programs submitted to us. And since 2011, only 2. So in recent times, 2.
Okay. I'd also like to bring up the risk limits issue. The proposed rule would have expanded upon the existing requirement promulgated under Core Principle D that a DCO impose risk limits on members by adding a requirement that risk limits should address positions that may be difficult to liquidate. In response to comments both from DCOs and clearing members, so kind of both sides there, the final rule eliminated that proposed expansion of the risk limits requirement. Can you explain the significance of the phrase positions that may be difficult to liquidate and how DCOs currently address those concerns?
Sure, thank you. I think it should be noted that in the May time period when this was originally proposed, there had been a default at a clearinghouse in a jurisdiction that we don't regulate, and that default caused, I think, notoriety globally. And with that notoriety, and I think the thought process that people had, we thought it prudent at the time to put a question out about risk limits. And I think that, as you rightly said, the comments that we received, nearly all of them, if not all of them, did not like the idea of imposing risk limits. And one of the reasons why they didn't like imposing risk limits is that in many ways they thought that that idea was already being dealt with in the form of margin requirements. And I think that, if I may, as I recall, there was a response that I thought was important that illustrates that point. A response said that margin requirements can more effectively account for the liquidity risk associated with specific positions held by specific clearing members because margin requirements can be tailored to the risks and particular attributes of each relevant product, portfolio, and market. The margin requirements can then serve as the one single input a DCO uses in determining appropriate risk limits. And I think that the staff and I discussed that point was rather salient simply because risk can mean many things to many people, whereas a DCO today can define risk the way it thinks it needs to and then can manage that risk in the form of a single concept called margin. And so we decided to accept the proposal or the comments by the commenters to say that using risk limits as a bright line feature would not be something we would entertain, but we would rather refer back to the wisdom of what clearinghouses currently do, which is use margin as the methodology by which they limit those risks.
Yeah. So as I think about what you just said, I think that seems to me to indicate that there are already risk limits. They're not just placed on customers directly. They're placed on customers' financial resources through the imposition of liquidity and margin concentration charges.
That's exactly right.
Yeah, okay. Thank you for that. And Commissioner Stump asked my question on the individual customer accounts reporting. So let me just thank you, Clark, Eileen, and Parisa, for your hard work on this rule and for meeting with me and my staff. Very helpful meeting and answering all of our questions. I'd like to thank the staff of the Commission generally for all of their hard work over this last year, as well as my colleagues. I think Commissioner Berkovitz at one point said we can disagree without being disagreeable. I think we can disagree while being agreeable. And I think it's even a fact that not only are we colleagues, but I think there are friendships that exist up here, which I highly value. So I'd like to wish everybody a happy holidays, a happy break, an early Happy New Year, and thank my team for their dedication, Kevin Webb, Marco Bailey, and Peter Calls. I couldn't do this job without them, so thank you to all of you. Thank you.
Thank you very much, Commissioner Quintens. I think my colleagues have asked all the questions that I had about this rule. The only thing I want to say in closing, particularly as members of the public are watching this, is that I think we can't emphasize enough how critical clearinghouses are to make our futures options and a large swath of our swaps market work. At taking away and removing counterparty credit risk really makes our derivatives markets able to work. And so one of the most critical responsibilities of the CFTC is clearinghouse, what we call derivatives clearing organizations, but the shorthand is clearinghouse or CCP, supervising and regulating them. Now, I believe our clearinghouses are the soundest and the most resilient in the world, and we need to continue to keep them that way. One of the things that strikes me is when I hear the term prudential regulators thrown around in Washington, and even when I look at the Dodd-Frank Act or the implementing regulations, I am astonished that the CFTC is not listed among them, because I don't think anything can be more misleading than that. We are the nation's chief prudential regulator for derivatives clearinghouses. We do prudential supervision and regulation when it comes to clearinghouses. And as a result, our Part 39, which sets out the statutory core principles and implements them, is really critical to remain up to date. So as technology changes, as market-driven changes occur, we've got to make sure they are amended and they're kept up to date. And today, the amendments that you've worked so hard on over the past few months codify nearly a decade of best practices adopted by our clearinghouses under our core principles. So the United States, I think, remains at the forefront of CCP regulation and supervision. So I am very pleased to support them. So with that, are the commissioners prepared to vote? Okay, Mr. Kirkpatrick, would you please call the roll?
Thank you, Mr. Chairman. The motion now before the Commission is on the adoption of the final rule on amendments to Part 39 of the Commission's regulations. Commissioner Berkovitz.
Aye.
Commissioner Berkovitz votes aye. Commissioner Stump.
Aye.
Commissioner Stump votes aye. Commissioner Benham.
Aye.
Commissioner Benham votes aye. Commissioner Quintens.
Aye.
Commissioner Quintens votes aye. Chairman Tarbert.
Aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 5, the noes have 0.
Well, I'm pleased to say then, the final amendments to Part 39, which will now be promulgated, have been so on a unanimous basis. Thank you. Before we move on to closing statements, and I'm not sure we need to make closing statements. Okay. Well, then before we adjourn the meeting, I'll ask whether there's any other commission business from my colleagues. Okay. Well, I have 2 final items of commission business, and don't worry, they're going to be quick. First, I'd like to announce the release of staff no action release for the transition away for LIBOR to alternative reference rates. We wanted to move quickly to get relief out there, and we expect other regulators will follow. I want to thank in particular Commissioner Benham for your leadership on this issue. And I also, of course, thank the staff for your hard work. And again, this also involved all 3 of our policymaking divisions coordinating. So well done on that. The second and final piece of other commission business is going to be a fun one. As you are all aware, 2020 marks the CFTC's 45th anniversary. Now, to celebrate this milestone, the CFTC has purchased 4 wooden flags from the company Flags of Valor to hang in each of our agency's offices, Chicago, Kansas City, New York, and here in our Washington, D.C. headquarters. These are beautiful pieces of artwork, and each one is handcrafted here in America by a U.S. military combat veteran. Now, the one that is going to hang here in the lobby of the CFTC in Washington was made by a 14-year veteran of the U.S. Air Force who fought in Operation Iraqi Freedom, Operation Enduring Freedom, which was Afghanistan, Operation New Dawn, and Operation Inherent Resolve, which was the fight against ISIS. So now I would like to invite our Executive Director, Tony Thompson, who also happens to be a retired Air Force colonel and the chair of our newly created Veterans Affinity Group, to unveil our flag. And if yep, there we are. Fantastic. Isn't that beautiful? Excellent. So it has the CFTC seal on it, on the wood, and it says in commemoration of our 45th anniversary. So these will go up starting in the new year in all of our 4 offices. And so it is an honor to have this as a fine tribute to not only the service of our veterans, but also the service of all of us here at the CFTC to celebrate our 45th anniversary. Any other commission business? Okay, well with that, there being no further business, I'd entertain a motion to adjourn the meeting.
So moved.
Those in favor of adjourning the meeting will say aye. Those opposed, no. The ayes have it. Again, I'm so grateful for the CFTC staff, the staff of my fellow commissioners, my own staff in the chairman's office, and of course my fellow commissioners for making this such a great year. Thank you all very much, and I will see you in 2020. We're hereby adjourned.